All are requested to kindly switch off their mobiles or keep them on silent mode.
I have your Lordship's permission to commence the proceedings of the court. Mr. Attorney.
Honorable the Chief Justice of India, Honorable Judges of the Supreme Court, the Solicitor General of India, Additional Solicitor General, President and Office Bearer of the Supreme Court Bar Association, the Office Bearer of the Supreme Court Advocates and Record Association, members of the bar, my dear friends at the bar. While liberty may lie in the hearts of all humans, it must also be secure to all under all times. Resilient social norms and constitutional orders must also remain intact in the midst of waves of social and political misadventures. Constitutional architects who can dig deep and wide enough and who can transcend partisan ideological demands of political party affiliations and stand by those values occupy that sphere of liberty architects. Mr. Fali Nariman was one such architect. When he gathered to pay homage to such giants, who have not only enriched our jurisprudence, stood as an icon, and taught the highest values of the profession, but also showed us the courage and conviction to stand by values in other public callings, we find it difficult to gather our chronicles about them and compress them. Talk of the march of Indian constitutional law without reference to Mr. Fali Nariman would be like marching with a flagpole without the flag. It's customary to set out biographical details, the outstanding ones, to fill the homage pages. What is difficult in connecting the life dots and his contribution is the vastness of his life canvas. I have endeavored to capture a few remarkable and unique contributions made by Mr. Nariman and to invoke our own commitments to such causes, subjects, and values. The stories of the world of arbitration, both international and national, cannot be written fully without mapping the roles played and responsibilities undertaken by him. Ambassador Venu Rajamani, in his message penned a few years ago for the book on international arbitration in honor of Mr. Nariman, said that, for us in India, 91-year-old Fali is a national treasure. And he paid rich encomiums to the range of his contributions, and particularly about his work in the Kishan Ganga international arbitration administered by the PCA. Chief Justice Chandrachud, writing in the same volume, said, countless efforts have rested easy on Mr. Nariman's shoulders. and admiringly spoke about the notable contributions made by him to the world of arbitration. In the 10th annual Goff lecture, by Narman, he critiqued what he called the mills of arbitration and cautioned against the transformation of arbitration into international disputology. The insights he gathered from his engagement in the international arbitration scene over a period and their encapsulation in several writings from 2003 to 2020 has given us a rich and coherent jurisprudence of the arbitration world. Mr. Brooks Vidali, writing the same volume, fondly talks about the long and fruitful relationship between the Permanent Court of Arbitration and Mr. Nariman. The pages of Indian constitutional law are copiously filled by his numerous engagements in cases of perennial significance. But one case that has rendered invaluable support for invocation of international law to be embedded in domestic law is the Vishaka Principle. His articulations Vishaka are now an integral part of public law. He remained the president of the Bar Association of India for more than 2 decades. He wrote regularly for the Indian Advocate, the journal of the Bar Association of India. The range of his pieces capture the width of his understanding and the unfading commitment to rule of law and human rights. Mr. Nariman was active and alive to political and legal developments till he breathed his last. Nariman rose in the recent electoral bond judgment, a quote. I am particularly impressed by that a five-judge bench has held in no uncertain terms that manifest arbitrariness is enacted now as an integral part of Article 14. I do hope that this will enable the Supreme Court at some point in the future to strike down the no bail for now provision in the recently enacted laws. This was his youthful reaction to current events. In his autobiography, Before Memory Fades, Nariman recounted why he returned his brief to the Gujarat government in the Narmada rehabilitation case. The abhorrence he must have had against emergency and its perils must have persuaded him to do so, troubled by his conscience against any injustice. Mr. Nariman, like Justice Krishnaya, used to say that he is a Nehruvian. The book he strongly recommended always was Jawaharlal Nehru's book, Discovery of India. This was his sharing his identity with Justice Krishnaya. Relying on this book, he commented that acceptance of all diversity is a sole ideology that could hold India together. According to Mr. Nariman, whatever the source from which minority derives its existence, religious, ethnic, or linguistic, the rest of society has to make a conscious effort in coming to terms with it. But the fact of life is that the larger the majority community with greater political power, the lesser the inclination to make efforts to build bridges, unquote. Civil liberties, fundamental rights, free speech, press freedom, cultural and educational rights of religious and linguistic minorities, the right to property, among others, were all dear to his heart. They were so dear to him that he always wrote and talked about all of them. Being a foremost lawyer in a corporate matters, as in any other field, Mr. Nariman was a natural choice to represent Union Carbide Corporation in the Bhopal gas tragedy case. Professor Bakshi spoke against Mr. Nariman for his role in the Union Carbide case. Bakshi's critical letter and his reply to her faithfully published by Mr. Nariman in his autobiography, in a later interview with Karan Thapa, he expressed regret for his decision to appear for the Union Carbide Corporation. How many of us are made of such metal? He declined the judgeship. The loss to judiciary, however, became a gain to the parliament much later. Presidents ranging from R. Venkataraman, K.R. Narayanan, Dr. APJ Abdul Kalam consulted him on important constitutional issues. His report of the long line of public figures who took consultation with Mr. Nariman as a persuasive element included former Prime Minister Vajpayee, Deputy Prime Minister Advani, Lok Sabha Speaker Somnath Chatterjee, Dr. P.C. Alexander, Dr. Karan Singh, and many members of parliament from different political parties who admired the jurist in Mr. Nariman. In one of his speeches to parliamentarians, Mr. Nariman elaborated on one of his favorite judgments, and that was judgment by Justice Chinnapareddy in Bijoy Emmanuel. He said, our tradition teaches tolerance, our philosophy teaches tolerance, our constitution preaches tolerance, let us not dilute it. Fali said, extolling the parliamentarian to make it a policy of the nation. In 1999, when Prime Minister Vajpayee had recommended to President K.R. Narayanan the name of Fali Nariman for being nominated at the President's discretion to Rajya Sabha, it is said that the tough former diplomat Brijesh Mishra, Principal Secretary of the Prime Minister, barely suppressed happiness to convey the glad tidings. I think the President will be pleased with the name. It will set the credit of the Prime Minister and his advisors, but most of all, the credit of Mr. Nariman, stature. No one thought the renowned jurist and the quondam additional Solicitor General of India would, as a member of Parliament, be soft on the ruling establishment or somehow got co-opted by it. The thought simply did not occur to anyone. And that is what called independence, and that's what called autonomy, as somebody says. Nominated MPs get very little speaking time, but some people impact their surrounding by their mere presence. Nariman did that in the Supreme Court and in the upper house of Indian Parliament. On January 27, 2000, President Narayanan, while addressing members of Parliament on the occasion of 50th anniversary of the Republic of India, said, quote, when there is so much talk about revising the Constitution or even writing a new Constitution, we have to consider is the Constitution that has failed us or whether we have failed the Constitution. And quote, from the galleries, I noticed, he says, I noticed Mr. Nariman erupt in delighted applause, thumping the desk in front of him with the central hall resounding with the approbation. And as he was on my way out, he came up to me and said, brilliant, brilliant, our president is brilliant. Mr. Nariman, being in Parliament, was akin to a conscience keeper, being in the atrium of India's legislative genius. He represented the Constitution's foundation objectives, his driving force, which was about rights and duties, woven into the resplendent short silk of democratic republicanism. During his 6 years as a parliamentarian, the world moved from the 20th century to the 21st. And Mr. Nariman moved from spending time at the bar and before the bench to the red carpeted and maroon upholstered chambers of Parliament. He introduced 4 private member bills in the Rajya Sabha, namely the Disruption of Proceedings of Parliament, Bill 2004, the Judicial Statistics Bill 2004, the Constitution Amendment Bill 2004, to amend Articles 217 and 224, and the Representation of People Amendment Bill 2004. He said he received assurance from the government that it would look into matters and 4 questions raised by him relating to budget allocation for elderly persons, prohibition of contract labor, village public telephones, and a general issue relating to Central Vigilance Commission Bill 2003. Some of them have become legislative enactments now. In a country like India, so diverse, so variegated, there is another side to every other side as well, inside every inside. And so be just as one can be, but you will always steal someone out of justice. Mr. Nariman knew this. Nariman called attention to motions relating to the great situation in Maharashtra due to unprecedented rain and the hike in petrol and diesel price in August 2005. His special mention of Rajya Sabha helped maintain educational autonomy in universities. He also introduced the report of the Committee of Privilege to the Rajya Sabha on December 18, 2000. He has participated in debates on many government legislation and took interest in the lawmaking process. In Mr. Nariman's death, India has lost its tallest spokesman for honesty in public intent and private conduct, probity in public service and private enterprise, and simple decency in public dealing and private equation. He was free of all sanctimony, all pomposity. The brightness of his professional life was so blinding that to miss taking adequate notice of his parliamentary life. He will be failing in our duty if we do not stop and reflect on the life and works of Mr. Nariman as a parliamentarian par excellence. The Indian Parliament is richer today due to his debates, his interventions, and time can never erode the pillars of strength that Mr. Nariman has added to the edifice of Parliament and parliamentary democracy. He led a full life. He has given unto us a great gift in Justice Rohinton Nariman, who has his credit a remarkable professional career on outstanding judicial contribution. Just a few days before Mr. Nariman laid his physical frame to rest, I was with him, had a warm and delightful exchange of views, and little did I knew that I will see him not again. I have several fond memories of my interactions with him, and they will all remain my treasure chest. May his soul rest in divine grace.
Honorable Dr. Chief Justice D.Y. Chantu, Chief Justice of India, other Honorable Judges of Supreme Court, learned Attorney General for India, Mr. R. Venkatramani, learned Solicitor General for India, Mr. Tushar Mehta, family members of late Mr. Fali S. Nariman, including his noble son, Honorable Mr. Justice Rohinton Fali Nariman, who served as Supreme Court Judge and Solicitor General for India, learned Additional Solicitor General of India, including Mr. Vikramjit Banerjee, Aishwarya Bhati, and former Additional Solicitor General Mr. C.S. Vaidyanathan and Mr. Viswajit Bhattacharya, former President of Supreme Court Bar Association Mr. Dushyant Dave, and present Vice President Mr. Sukumar Patjoshi, Honorary Secretary Mr. Rohit Pandey, Joint Secretary Mr. Manish Kumar Dubey, Treasurer Yogendra Pawar Jha, Joint Treasurer Mr. Amrinder Kumar Singh, and other distinguished office bearers and members of Supreme Court Bar Association. President Mr. Manoj Kumar Mishra, Vice President Sanyasis Mukherjee, Honorary Secretary Devar, Joint Secretary Ms. Rasmi Malhotra, Treasurer Mr. Puneet Singh Bindra, and Joint Treasurer Mr. Sachin Sharma, and other distinguished office bearers and members of Supreme Court Advocate on Record Association, officers of Registry of Supreme Court, including Secretary General Mr. Atul M. Korhekar, distinguished media persons, my brothers and sisters in legal profession. We have gathered here to pay homage to our most distinguished legal luminary and pure soul, late Mr. Fali S. Nariman, Doyen of the Bar, who passed away in New Delhi on February 21, 23 at the age of 95. In his loss, a void is created among the legal fraternity worldwide. He was a jurist par excellence and a champion of human rights, and he made an indelible imprint in the legal profession. Mr. Fali Nariman started the general practice of law in 1950. Soon, Mr. Nariman built up a large and lucrative practice, particularly in commercial law and civil law. Indeed, he dominated the commercial code. He assisted both Mr. Ashok Sen and Mr. Nani Pal Kiwala in Golaknath case. Mr. Nariman was offered a High Court judgeship in 1996, though he was only 37 years old, and as required in those days, it had the express approval of the Honorable Chief Justice of India, but he respectfully declined that offer. His appearance in an election case for Mr. H.R. Gokhale, later Union Law Minister, felicitated his first independent appearance in the Supreme Court, and he shifted his practice to the Supreme Court. He was designated as senior advocate in 1971. In 1972, Mr. Nariman was appointed Additional Solicitor General of India. As a champion of human rights, he resigned as Additional Solicitor General of India when emergency was imposed in June 1975. Thereafter, for over half a century, he practiced continuously in the Supreme Court of India and appeared in hundreds of leading cases which bear testimony to his contributions to the growth of law. Mr. Nariman had served as Vice President and President of Law Asia. Mr. Nariman was honored with the Padma Bhushan in 2007 and Padma Bhushan in 1991 by Government of India. He has been a mentor to Bar Association of India. He was a nominated member of Rajya Sabha from 1999 to 2005. His advocacy and lucid arguments before the judges are worthy of emulation, particularly by the younger members of the bar. He has inspired generations and has made them believe that one can fulfill every dream with hard work and sincerity. Being the president of Supreme Court Bar Association, I offer condolences to his family and respectfully pay homage to him. Jai Bharat.
My esteemed colleagues, Mr. R. Venkatramani, the Learned Attorney General for India, Mr. Tushar Mehta, Learned Solicitor General, and law officers, presidents of the SCBA and SCORA, distinguished members of the bar, members of Mr. Nariman's family, and part of our own extended family, Justice Rohinton Nariman, Sanaya, Neena, Khurshid, Rohan, Mr. Subhash Sharma, who was not just a junior for Mr. Nariman, but a part of the family, and members of the registry. So much has been said about Mr. Fali Nariman. Accolades and tributes have been showered in rich abundance to his memory. So much yet remains to be said. The universe of infinity or the infinity of the universe, whichever way we perceive it, defies prose and verse. The values which Fali Nariman embodied, unflinching ethics, indomitable courage, and an unwavering pursuit of principle, provide a balm to the soul, not just to the profession, but to our nation. In the Iliad, Homer compares people to leaves, noting that in the winter they are blown to the earth, and as spring comes again, the budding wood grows once more, causing Homer to state, and so with men, one generation grows, another dies away. But some names remain. Our nation has been blessed with several talented legal minds both before and after we gained independence. But every now and then, a lawyer transcends advocacy to become a leader and pillar of the community. They do so first and foremost through their outstanding legal acumen and incredible work ethic. These foundational attributes are buttressed by subtler but equally important qualities, such as a keen understanding of a lawyer's role in our nation's socio-legal fabric, their integrity and courage in the face of injustice, and perhaps most of all, their compassion and willingness to help others. Through their actions, the cases they argue, their written work, and the positions they hold, entire eras of the legal profession come to be associated with their presence. Mr. Nariman was unquestionably a symbol of all this and more. While Mr. Fali Nariman's contribution to the Indian legal profession was the result of his hard work, his very presence in India was the result of unforeseen events, or as some would say, fate. Born on 10 January 1929 in the territory that was then Burma, it was the Japanese invasion of the Indo-Pacific that caused Mr. Nariman's family to migrate to India. The arduous trek in the face of incessant bombing instilled steel in the young child, who by his own admission had until then a rather devoted upbringing. He completed his secondary education at the Bishop Cotton School in Shimla and secured a degree in history from St. Xavier's College in Mumbai. At the Government Law College in Bombay, he was instructed by several practicing members of the Bombay Bar, including Nani Palkhiwala, Yashwant Chandrachud, and Jal Vimadalal. He was, and with the benefit of hindsight, perhaps unsurprisingly, an outstanding student who was always amongst the top of his class, securing the Kinloch Forbes Gold Medal in Roman Law and Jurisprudence, and standing first in the advocate's examination conducted by the Bar Council. The early years of Mr. Nariman's career were spent, like many of us, carefully observing and assisting senior counsel. He joined the chamber of Sir Jamshedji Kanga in Bombay. The chamber had a veritable assembly line of brilliant juniors, including Marzban Mistri, Rustam Kola, Hormazji Sirvai, Kharseji Bhaba, Soli Sorabji, Jal Vimadalal, and Nani Palkhiwala. Fali Nariman's presence rested easy amongst his peers. He excelled, arguing case after case before distinguished judges, M.C. Chagla, P.B. Gajendra Gadkar, who would be later elevated to the Supreme Court and ultimately hold the position of the Chief Justice of India, S.R. Tendolkar, and J.C. Shah, to name a few. Mr. Nariman always insisted that the more work you'd have, the sharper are your mental faculties. Living by this principle, after a full week arguing in the Bombay High Court, Mr. Nariman often used to travel to Pune to practice in the district court, honing his skills in the art of trial advocacy. Though drawn from the original side, he had no air of superiority or condescension. The phrase, all roads lead to Rome, can aptly be modified for a great many Indian lawyers to say all roads lead to Delhi. And so it was with Mr. Nariman. Despite his long-standing loyalty to the Bombay Bar, he was gradually pulled in by the gravitational force of this court, which is the ultimate arbiter of constitutional disputes, and the nation was better off for it. While still practicing in Bombay, he began appearing at the Supreme Court, most notably assisting both Ashok Sen and Nani Palkhiwala as they argued the landmark case of Golaknath versus State of Punjab before the 9 judges of this court in 1967. In 1971, he was designated a senior counsel in the Supreme Court. In 1972, he was appointed Additional Solicitor General of India at a time when the Union of India had only 3 law officers, the Attorney General of India, the Solicitor General, and Mr. Nariman, the Additional Solicitor General of India. As Nariman says in his book, Before Memory Fades, if foreigner in Delhi has to establish himself both in integrity and ability, only then will the Supreme Court bar accept them as one of their own. But once they do so, its members are the most affectionate and loyal of all comrades. Our bar would submit to a decree on admission when I say that Mr. Nariman passed this test with flying colors. He represented the Union of India in this court and at various other fora during his tenure as ASG. He argued seminal cases such as Bennett Coleman versus Union of India. He was a spirited representative of India at international events such as the conferences of Law Asia and the International Law Association. An embodiment of the generous cultured traditions of the Parsi Zoroastrians, he and his gracious spouse Bapsi were full of mirth. They were joyous and spread joy around, complemented in good measure by dhansak and a good tipple. Fali possessed an unending compendium of stories about yesteryear. Bapsi and Fali were never short of his generous chuckle and the glint in the eye. With the imposition of the internal emergency in June 1975, Fali Nariman resigned as Additional Solicitor General. As Martin Luther King once mused, cowardice asks the question, is it safe? Expediency asks the question, is it politic? Vanity asks the question, is it popular? But conscience asks the question, is it right? Mr. Nariman was guided by only one question, the last, is it right? In his later years, Mr. Nariman often described how in the days following his resignation as Additional Solicitor General, visitors to his house dried up to a trickle. However, he continued accomplishments at the Supreme Court are a testament not only to his enduring legal prowess that saw him through turbulent times, but also to that finest tradition of the bar in rising above the disagreements of the day, to unfailingly serve their clients, assist the court, and work towards our nation's betterment. Despite appearing for countless clients of various and diverse backgrounds, creeds, and political dispensations, Mr. Nariman always recognized that his highest duty was to the court and the Constitution. In Air India versus Nargesh Mirza, Mr. Nariman was tasked with defending the national carrier's policy of compelling air hostesses to retire upon their first pregnancy. Recognizing the incongruity between Air India's policy and the prohibition on sex discrimination found in Articles 14 and 15 of the Constitution, Mr. Nariman did not unthinkingly defend the policy, but instead impressed on Air India the need to amend their ways. As Justice Syed Murtaza Fazal Ali recorded in the case, in fact, he says, as a very fair and conscientious counsel, Mr. Nariman realized the inherent weakness and the apparent absurdity of the aforesaid impugned provision. And in the course of his arguments, he stated that he had been able to persuade the management of Air India to amend the rules so as to delete first pregnancy as a ground for termination of the service. The ultimate test of a moral person is their willingness to raise a voice for justice, even when it means rocking the boat. In this case, as he would say, the aircraft. And Mr. Nariman was always willing to speak for what was right and just. Mr. Nariman's distinguished career continued throughout the remainder of the 20th century and into the 21st. His arguments in key cases influenced the very foundations of constitutional and public law, such as his noteworthy contributions to the second, third, and fourth judges' cases on judicial appointments in 1993, 1998, and 2014. His client, as he would say, was the independence of the judiciary. He argued cases on the rights of minority educational institutions under Article 30 of the Constitution, culminating in the seminal TMA Pai Foundation versus the state of Karnataka decision. Away from Delhi, he was also a seasoned lawyer before various tribunals established under the Interstate River Water Disputes Act 1956, representing the state of Karnataka for over 30 years in the Kaveri water sharing dispute. Our time here is too brief to recount even a fraction of his noteworthy arguments in our courts, but I would be remiss to not mention the arguments he advanced in Suresh Kumar Kaushal versus Naz Foundation. Mr. Nariman argued that Section 377 of the Indian Penal Code cannot criminalize sexual acts between consenting adults and urged the court to change with the times. Despite the court upholding the provision, the passage of time and the eventual overruling of Suresh Kaushal in Navtej Singh Johar has since vindicated Mr. Nariman's argument and his constitutional vision of equality and dignity. The hallmark of a great lawyer is not one who wins, but one who fights well, and in doing so furthers the judge's own understanding of the issues. Mr. Nariman was truly amongst the very best. Lawyers are often likened to soldiers, engaged in gladiatorial combat before the bench. But in his own tribute to Motilal Sedilwad, Mr. Nariman distinguished between soldiers and grand old lawyers, noting, "Old soldiers never die, they only fade away. Grand old men only die, but they never fade away." Words that have a particular resonance as we are gathered here this morning. Mr. Nariman's contribution to the legal profession transcended the court. He was the president of the Bar Association of India from 1991 to 2010 and a member of the International Commission of Jurists from 1995 to 1998. He served as a vice chairperson of the Court of Arbitration of the International Chamber of Commerce and as a member of the London Court of International Arbitration. Public law became a part of his flesh and blood, but he was at heart a quintessential lawyer who had found his moorings in commercial law. Arbitration was close to his heart. Conferences of the Permanent Court of Arbitration were never complete without his presence. In 1991, he was awarded the Padma Bhushan, and in 2017, the Padma Vibhushan. In his time, he also served as a nominated member of the Rajya Sabha from 1999 to 2005, which the learned Attorney General has recounted. Despite scaling these incredible heights, Nariman always maintained that greatness and modesty go hand in hand. He was a man truly in the mold of his mentor, Sir Jamshedji Kanga, who famously, even at the age of 92, always insisted, "I am still learning." Even after retiring from active practice, he authored numerous articles and books that have inspired countless lawyers, the most recent of which, titled "You Must Know Your Constitution," was published a few months ago. By writing opinion pieces in newspapers on complex legal issues and constitutional doctrine, Mr. Fali Nariman tried to ensure that legal discourse is not limited to lawyers and judges and reaches the wide spectrum of society. A few months ago, I had written to Mr. Nariman requesting him to contribute an essay to a volume on 75 years of the Supreme Court that we will be publishing in a few months. At about noon on the day before his passing, we received an email with his essay with a gracious hand-signed note. I'm also reliably informed that right until the night before his passing, he was meticulously settling the draft of a written submission for an upcoming Constitution Bench hearing on arbitration law. His mental agility, dedication to his work, and commitment to the law remained uncompromised till the day he finally rested. Mr. Nariman's life and career before our courts lived up to the highest ideals of the legal profession. No matter the client, the government, or the case, Mr. Nariman sought to advance a vision of the law grounded in liberty, equality, and justice, the foundational values of our Constitution, and ultimately our society. No matter the occasion or the opponent, he conducted himself with grace and poise. As recently as in 2022, he wrote for the Indian Express that a futuristic court is not just one that is technology-enabled, but also that which is independent. He wrote, "First and foremost, the judiciary as an institution needs to preserve its independence. And to do this, it must strive to maintain the confidence of the public in the established courts. The independence of judges is best safeguarded by the judges themselves through institutions and organizations that the law empowers them to set up." Mr. Fali Nariman's life straddled time and roles of personality. He embodied the fierce and unwavering commitment to the rule of law, which has defined the position of our bar after 1947. As an inveterate lawyer, Fali Nariman was that and more. He was a mentor to many on the bar and the bench. He had perfected the fading art of letter writing. He would share an article or eagerly inquire about areas of emerging interest like technology, in which he was a self-confessed beginner. While he was not one to mince words on a judgment he disagreed with, he was equally the fond and generous senior. A day before his passing, I received a letter from him on a recent judgment of the Constitution Bench. Mr. Nariman fought many battles. Some of these battles continue needing to be fought. He narrated a story involving a conversation between two distinguished lawyers in our bar library during the course of the emergency. One was drawing puffs on his pipe. The first of the two lawyers said to the other, "Tame bolo," you speak. The other said, Tame bolo, you speak. When many voices fell silent during difficult times, Nariman's resounding baritone resonated in the walls of the court and beyond. His voice represented the conscience of the nation. In the end, it was not Mr. Nariman who gave up on these battles. It was only his body. His soul will live on in the many lives he touched and the thousands more he inspired, and his memory will always serve as a guiding light for those who pursue justice in these halls. I request you all to stand up and observe 2 minutes silence in memory of late Shri Harias Nariman, Senior. The court will sit for normal work at 11:30 a.m.
Citizens of the court.
కొత్త జోడీ పిచ్ పైకి వచ్చింది.
సావిత్రి, ఈ పార్ట్నర్షిప్ ఏంటో చాలా కన్ఫ్యూజింగ్ గా ఉంది.
పరిస్థితులు అంత అనుకూలంగా లేవు.
కరెక్ట్. వీళ్ళెవరు సెలెక్ట్ చేశారు?
టాటా ఐపీఎల్ జియో సినిమాలో ఎక్కడో కాదు అంతా ఇక్కడే.
May I please, your lordship?
1 second. Just one second.
Start this proceeding. But I am appearing on behalf of the major broad industry association, which is the ASSOCHAM, Lord, and CI. But we have filed applications today morning. Lord,
If the application is not numbered, it is not registered, we'll follow what sauce for the goose is sauce for the gander. Mr. Rodhi, sorry, no oral mentioning in my court.
No, I'm not, Lord, I'm in the matter I'm saying. I am saying.
We have no such application on board. Let it be circulated. We'll deal with it in the normal course.
But Lord, I am respectfully submitting. If
Sorry,
your lordship make
appearing
an order
for big
today,
clients, we will not tolerate this. You have to follow the rules in my
but
court.
Lord, if your lordship make an order today, my application will be infructuous. I am saying kindly defer the issue of grant of alpha numerical.
You are aware of what is proceeding going on. You could have intervened at that stage. What is this after the judgment is passed? You want to intervene now?
My Lord, the order is of 15th March. As
You are aware about the proceedings pending before this.
but Lord, we were not parties anywhere. We were not parties at any time.
Everybody, the whole world knew that this matter was being heard.
Lord, I have
Come
no.
back 1 second, Mr. Rodhi. You come here after the judgment is delivered. You are now, you file an application. That's not the way.
Lord, I have come only in regard to
Circulate and-
15th March. Kindly appreciate.
No, Mr.
I have no problem in
Rodhi,
declaration
hear you.
of the list of donors
Rodhi.
or the list of recipients.
Mr. Rodhi will not hear you right now. We have a specific application which is on board. You ask your advocate on record to follow the procedure. File an email. It will be dealt with by my registrar listing. We'll take a, we'll get
But
it. No.
I am saying
No,
kindly, Lord,
If I do it for Mr. Rohatgi, senior
No, no,
counsel, then Mr. Rohatgi, you look at me. As Chief Justice, I have no face to tell all the other juniors to whom I declined list mentioning in the morning. What sauce for the goose is sauce for the cat.
mentioning, I am not appearing in the matter and making a submission.
We have no such application on board before us.
Lord, I have got it with me.
I've made my
My lord, the entire,
I have emailed
entire judgment has,
second, do wait. One at a time. Sorry, Mr. Rodgi. Yes.
no, my lord, my submission is the entire judgment has been rendered behind the back of the public at large. This judgment doesn't constitute res judicata. This judgment doesn't constitute res judicata.
1 second.
Yes.
1 second.
This
1
judgment is
second.
void.
Please listen to me. You are not, 1 second.
I am a citizen of this
1
country.
second.
Yes.
Don't shout at me.
No, I am very soft.
Please listen to me.
Yes.
This is not a Hyde Park corner meeting, okay? You are in the court.
Yes.
You want to move an application?
No, my lord.
File an application. What I told Mr. Rodgi applies to you.
No, my lord, the question is, my lord,
There's no question you've got.
my friend has come.
Mr. Nedumbara, 1 second.
Yes.
You've got my decision as Chief Justice. We are not hearing you. If you want to file an application, move it on the email. That's the rule in this court. No
my lord,
further.
we will go by what your lordship.
All, please.
Whatever your lordship says, we will go by that.
Do you want another contempt notice?
No, my lord, your lordship will go by
You have
whatever
had
your
enough
lordship
committed
says.
Bombay.
Only I have said what I wanted to say. That this judgment is rendered behind the back of the people of this country. It doesn't bind us. It doesn't constitute us. It is not a representative.
Do not,
at all.
please, once we have said no, please move the
I
application
accept
by email.
what your lordship says.
Do not continue and persist.
Yes, I only said it was not a representative proceeding.
You are,
All the way come from Kerala.
you are obstructing in the administration of justice.
Pardon, my lord?
You are obstructing in the process of administration of justice.
Because the entire judgment is against, behind the back of these people. Parliament has been rendered
Hey,
irrelevant.
that's all. That's all. We heard that. Please, that's all. You made it.
We are in a democracy.
We will not hear you till you follow the procedure prescribed.
My lord, we are filing it.
Please do.
We are filing it.
Please do. We'll consider it afterwards.
Yesterday
That's
at
it.
10 o'clock.
I-
My friend came from Kerala to took a 1 o'clock flight.
Have not-
Be kind to us. Be
last-
kind to
That's
us.
all, please. We will not hear that.
In
Please
democracy.
call for the application. Please follow the application.
Democracy.
My lord, may I mention, my lord, my petition for suo motu that is pending. Whatever lordship want to do, that do only. I will not disturb lordship.
Mr. Agarwala, apart from being a senior counsel, you're the president of the SCBA.
Yeah.
You should know the procedure. You have written a letter to me asking me to invoke my suo motu jurisdiction.
Yes, my
You
lord.
have no locus to mention
So
anything.
that I should not
You
disturb
have to
lordship.
rest it with what you
We
have
should not waste it honorable time, court's time.
Fair
That's
enough.
why.
Lord,
Only that.
These are all publicity-oriented stunts. We will not permit it.
Not a handmaid of
Sir,
Whatever
please-
lordship feel better.
Mr. Agarwala, please keep it at that. I may have to say something more, which will be perhaps a little distasteful.
Manoj,
Please close it.
members of the bar who are
Mr.
senior to your lordship.
Majumdar, it is enough now.
Also senior to your
It
lordship.
is enough.
64-year-old man, Lord.
Be kind to us, later. We are very polite and begging with your lordship. Your lordship has a soft language.
Majumdar, we have been telling you that you are interfering, you are obstructing us.
No.
Now,
Look at it, be said.
if you don't stop, we will have to.
When we are not heard and we feel threatened. Sorry, Lord.
Follow the line.
Yes, Bala. Yes, hearing now. We issued notice on the last occasion to State Bank of India. Mr. Kapoor, you are appearing? You are appearing
Mr. Salve is also there.
for the State Bank?
That's right.
Yes.
But I appear for the State Bank.
Yes. Mr. Salve, in
Yes.
our order which we, in the judgment which we delivered, we had expressly asked State Bank of India to disclose all details. The language of the judgment was all details have to be disclosed. Therefore, that includes the bond numbers as well. So, let SBI not be selective in the disclosure of details. We intend to clarify that it shall disclose all details, including the bond numbers, and every part of the information which is in its possession and custody. Don't wait for an order of the court. We banked on the fact that the State Bank of India would be candid and fair to the court.
But I just, whatever your lordship say, if your lordship say bond numbers, you can disclose the bond number. There's no problem. Somebody can screen them.
Why has the SBI not disclosed?
I wanted to tell my lord how we understood your lordship's judgment. Give me 5 minutes only to explain our conduct. Well, of course, if your lordship say give anything more, everything will be given. But there's no question.
SBI's attitude appears to be: you tell us to disclose a particular detail, and we'll disclose it. That's not fair process.
How we understood.
This is the judgment of the Supreme Court. As chairman of the State Bank of India, I'm duty bound to comply with the judgment. I will disclose every part of the information which is in my custody as directed by the Supreme Court. Because when we said all details of the purchases, that means every conceivable detail which is available with State Bank of India. And we clarified by saying including. That should be, State Bank of India has the best legal advice open to it.
May I not take your lordship through the 3 orders to how we understood them? My lord, your lordship's first order was 12th April 2019.
Sure.
And we have, for convenience, my lord, we have put the 3 orders together. If your lordship just see that. We'll give everything, there's no question. Just to explain that it's not that the impression which is being created, my lord, is that State Bank of India has been playing ducks and drakes with the court. I just wanted to clear that up. If your lordship sees the 12th April 2019 order in paragraph 16, but I had asked my friend to make a little compilation of the orders so we could show them easily. Your lordship has not.
Yes, para 17, right?
Para 16, my lord.
16. You got this?
Yes.
Yes.
This is the interim order my lords had been pleased to make. After my lord noting all the changes, the court would have to ensure that any interim arrangement that may be made would not tilt the balance in favor of either of the parties, but the same ensures adequate safeguards against the competing claims of the parties which are yet to be adjudicated. In the above perspective, according to us, the just and proper interim direction would be to require.
Can we just see para 15 again, right?
Yes. The court therefore has to ensure that any interim arrangement that may be made would not tilt the balance in favor of either of the parties, but the same would ensure adequate safeguards against the competing claims of the parties which are yet to be adjudicated. In the above perspective, according to us, the just and proper interim direction would be to require all political parties who have received donation through the electoral bonds to submit to the Election Commission of India and seal cover detailed particulars of the donors against each bond. The amount of each such bond and the full particulars of the credit received against each such bond, namely the particulars of the bank account to which the amount had been credited and the date of each such credit. So, my lord, your lordships felt this would ensure transparency, that you give all this, but you keep it in a sealed cover. So, my lord, a political party doesn't need bond number. If a political party comes and says, I have received so much from so and so, that gives the requisite details.
We take it you're not arguing a case for a political party, right?
No. On the contrary,
For the state
I'm saying the reverse. I'm so sorry. I'm saying the reverse. But if a political
Para 16, Mr. Salve, was relating to the political parties who had to submit the data to the election commission.
Correct, and they have, and this has
no. That's a separate issue. Whatever they have declared or not declared, that's a separate issue. But as far as the judgment of this court is concerned, because you were also supposed to...
I'm coming in a minute. If your lordship will just give me 1 minute, how we understood it. Para 16, with, as my lord has therefore noticed, only required the political parties to give all these details. And these details have been given, my lord. If they have not been given, that's between the ECI and the political parties. As my lord, the Chief Justice said, I'm not preparing for a political party. Then, my lord, Para 17 was the mechanism. Your lordship said details will be furnished in respect of electoral bonds, the details of such bonds that may be received by a political party. Up to a date for issuing such bonds as per the ministry, that is February 19, will be submitted on or before 3rd of May 19. The sealed covers will remain in the custody of the ECI. So, my lord, we had no role to play. Your lordships had put this mechanism in place. In your lordship's judgment, your lordships dealt with the diverse aspects, including the need to preserve some degree of anonymity, and your lordships will not mark that in para 125, where your lordships discuss the electoral trust as an alternative to this system. And in the conclusions, which are para 218, if your lordships have the compilation, it would be PDF page 76.
Yes.
Your lordships do not say we direct the disclosure of information on contribution received by political parties under the electoral bond scheme to give logical and complete effect to the ruling. On 12th April, the court issued an interim direction order directing that the information of donations received from donations must be submitted by political parties. The court directed political parties to submit detailed particulars of donors against each bond, the amount of each bond, and the full particulars of the credit received against each bond, namely the particulars of the bank account to which the amount has been credited and the date on which such credit has been made. I'm only not saying this to explain how we understood the order. So this correlation between which political party has received money from whom comes in here, because the political party says, I have received so much money from so-and-so. Then it says, during the course of hearing, Mr. Sharma said that the ECI has only collected information on the contribution made in 2019 because of para 14 indicates direction was limited to contributions in that year. Your lordship then clarified para 13 and 14 of the interim order are extracted below. In the above perspective, according to us, the just and proper interim direction would be to require all political parties who have received donations through electoral bonds to submit to the election commission and sealed cover particulars of the donors against each bond, the amount of each such bond, and the full particulars of the credit received against each bond, namely the particulars of the bank account to which the amount has been credited and the date of each such credit. The details will be furnished forthwith in respect of electoral bonds received by a political party till date. The details of such other bonds as may be received up to the date fixed for issuing such bonds, including February 19, May 19, will be submitted on or before May 19, and the sealed covers will remain, etc. Then your lordships clarify, para 14 does not limit the operation of 13. 13 contains a direction in unequivocal terms to political parties to submit particulars of contributions received through electoral bonds to the ECI. Para 14 only prescribes the timeline for the submission on the contributions when the electoral bond should be done. In view of the interim order, the ECI must have collected particulars of contributions made to political parties through electoral bonds. In view of our discussion, the following directions are issued. The issuing bank shall stop issuance of bonds, which was done immediately. The SBI shall submit details of the electoral bonds purchased since the interim order by the court till date to the ECI, fully given, my lord. Details shall include the date of purchase of each bond, the name of the purchaser, and the purchaser of the bond, and the denomination of the electoral bond purchase. All these details are given. SBI shall submit details of the political parties which have received contribution through bond since the interim order till the date of the ECI. SBI must disclose each electoral bond encashed by the political parties, which shall include the date of encashment and the denomination of the bond. Now, my lord, as we therefore understood this, the political parties have come and said, we have received so much from so and so. The details which we will give will make the database complete so that we have who purchased, when he purchased, and when they have got. If the numbers are to be given, we'll give them. There's no problem. So, according to us, the data.
Mr. Salve, I have a few questions. First, tell us in what format is the data on the purchase and redemption of electoral bonds stored by the SBI?
So, my lord, as I had explained in the application which we filed, because at that time we were functioning under the edict of anonymity, which had not been stayed. So, at that time, we were directed to preserve anonymity, including we had to take measures that within the bank.
What is the format in which you maintain the data on purchase and redemption of electoral bonds? In what format do you store
in 2 silos. Your lordship noticed that in the next order. So the data is maintained in 2 silos.
You store it in 3 silos. From your application, it emerges now that you do it in 3 silos. The first silo is the bond number. The
bond number is only on the bond.
And the third is the redemption.
My lord, bond number is only on the bond, and it cannot be read except through under a UV light. That was only done, my lord, like authentication, because it was a bearer bond. That's what was sought to be.
The purpose of the alpha, and second question, what is the purpose of the alphanumeric?
The alphanumeric is the bond number which is visible only under a UV light.
Is it only a security feature, or is
it a security feature entirely?
In the audit trail, do you also?
No, my lord, audit trail is separate. That's why we do the entire KYC. In the KYC, we have a bond unique number. It's not the bond number. You have a marker number of a client.
Third question: how does the redeeming branch?
Yes.
How does the redeeming branch?
Yes.
Match the electoral bond number to determine that it is not a forged bond?
So they were not. That's what I'm saying. When they received it, the person encashing it gets it. He sees that it's a valid bond because you see the security feature. You don't keep a record of it. The physical inspection.
While redeeming it, the only way you can ensure that it is not a forged bond is to match the alphanumeric. Without
there's nothing to match. It's like seeing a currency note. It's like seeing a currency note. You know that's
the alphanumeric.
Yeah.
But cashed in the last 15 days because it's only valid for 15 days. So therefore, they will have to also match when was this bond.
I think Mr. Bhushan should hold his peace for a minute.
What is the information that you see when you scan the alphanumeric?
Malad, you see a number.
The details of the purchaser and the bank which issued the bond when you scan the bond?
No. That's what I'm saying. That correlation was not kept for the reason it's like this. Mr. A or Mr. B come and buy the bond. So they go to branch A. They do the entire KYC information is done, their bank account details, etc., everything is done. That is silo 1, if one may so call it, which is nothing near lordship's order. That's been fully disclosed. That bond finds its way into the hands of some political party. We don't know who gives it, how it goes, how many hands it changes. It finds its way in the. We next get to see the bond when somebody comes and says.
Mr. Salve, assuming that you construed our order based on the interim order merged with the final judgment of our court.
But even in the final judgment,
say that we will interpret our final directions in the light of the interim order, which has merged with the final judgment.
Your lordships,
all details.
That's why we came to my lord.
Mr. Salve, we'll clarify to put it beyond any.
No problem. No problem at all.
We'll say that now SBI will not only disclose the bond numbers, but it shall also file an affidavit again before our court saying that you have not suppressed you have not withhold any details in regard to this within the purview of clause B and C of para 221.
Correct. I don't think there's anything else which remains.
Details, you have to disclose all details. Let there be no Because the burden should not lie upon the court or the petitioners to say, but this one has not been disclosed, but now this has not been disclosed.
Now we'll disclose it, my lord, whatever.
We must have finality to it.
Yes, we'll do it, my lord. There's no problem. Just that this constant, my lord, the media constant beating down and the petitioners giving public interviews saying, we will take the State Bank to task and we will show this and we will haul them up for contempt, etc., etc. But we are also public institutions working in this space. And it's all right. People work, people acted on the face of this. Your lordships granted an interim order saying keep records. It wasn't at that time, my lord, subject to correction. I didn't find any order which says all further actions will be subject to the judgment or something. There was no such direction. Your lordships are at that balancing interim order. Now, whether completely you should lift the privacy or remove anonymity, better your lordships will.
Mr. Salve, the idea behind the interim order was in case the writ petition is allowed, then data should come out. And that's what exactly is required. Nothing more.
I must say so, my lord, as out of whatever, my lord, the Chief Justice is saying, your lordship will clarify, we will give every bit of information, relevant, not relevant, we'll give every bit of information which we have. So that, my lord, there should be no feeling that SBI is interested in somehow holding something back. I only want, my lord, to share one thing. My lord, your lordship's judgment is one of the leading judgments on the subject on transparency, voters' rights, and balancing democracy, balancing the competing virtues of and trying to minimize the role of money while recognizing the role of money in elections, etc. It goes over a lot of subjects. The one thing the lordship's judgment was not meant for, possibly, and not designed for, is to give birth once again to a now dormant PIL industry, which will go after each industrialist and say, investigate this, investigate this, investigate this, investigate that. And the idea is the voter should know, which is absolutely, and my lord say, give the bond numbers, we'll give the bond numbers. The voter knowing is one thing, but this as fodder for the next 10 years to have PILs saying investigate so-and-so, investigate so-and-so. That is, I don't think, the purpose of your lordship's judgment. That was not what it was meant for. And your lordship will see whatever safeguards need to be put in place.
Just one more thing.
I have 2 minutes, my lord, if your lordship permits. At the outset, my lord, on behalf of the central government, I completely disassociate myself with what Dr. Agarwala has written. It is completely unwarranted and ill-advised. I want that to be made very clear, my lord, on behalf of the central government. Now, my lord, I have something to share, and I have been watching this very painfully, my lord, outside the court. My lord, your lordships sit in kind of a silos. Your lordships are, my lord, in an ivory tower, not, my lord, in a negative sense of the term. But what we know here, my lord, your lordships never come to know. The way in which your lordship's judgment is playing out, my lord, something your lordships must, my lord, be informed as highest court of the country. But what has happened? My lord, our case was that we want to curb the black money. A criminal may have paid the donation, but ultimately the donation comes in the white economy and we could not persuade your lordships. My lord, your lordships passed a judgment. Lord, every one of us understood the judgment and the directions in a particular way, that what your lordship wants is not, my lord, kind of a witch hunting. Earlier, my lord, our case was that witch hunting would be by the political parties. If A party is given, B party in some other state might victimize the donor. Now, my lord, the witch hunting has started, my lord, at some other level, my lord, not at the governmental level. The application comes of the SBI before your lordships on 11th of this month, my lord, and your lordships also, my lord. That's how, my lord, we understood, clarified the position. But most serious things, my lord, start happening thereafter. Lord, those before the court started giving press interviews, deliberately embarrassing the courts, my lord, and there is, Lord, a non-level playing field. My lord, on this side, nobody can rebut that. Neither government can do, nor state bank can do, nobody else can do. Thereafter, my lord, a barrage of social media posts, my lord, at least intended to cause embarrassment, started during these 2 days. And thereafter, my lord, now it's anybody's field. It's an open field. Lord, statistics, your lordships are aware, can be twisted in any manner the person wants. It's a matter of, my lord, intelligence of the reader to understand. Now, my lord, based upon the twisted and other statistics, my lord, any kind of, my lord, posts are being made. I know, my lord, your lordships cannot control them. The question is, would your lordships, my lord, consider issuing a direction which has a necessary and inevitable fallout, which the court would not be able to control? Lord, that saying Mr. Rohgi gave this money to this, then they have their own conclusion.
Mr. Solicitor, we are only concerned about enforcing the directions which we issued in clauses B and C of Para 221.
That's
as judges, we decide according to the Constitution.
Correct, my lord.
We are governed by the rule of law. We are also the subject matter of comment in the social media and the press. But surely, as an institution, our shoulders are broad enough.
No, I'm saying, I'm not, my lord, for a second.
Our court has an institutional role to play in a polity which is governed by the Constitution and the rule of law. That's the only job.
Lord, my purpose is to inform your lordships that there is something else playing out which neither your lordships intended nor the scheme intended. And, my lord, kindly bear that fact in mind. On 11th of March, my lord, we thought that we are ad idem, that this information would help the voter to take a call whether to vote in favor of a particular party or not. My lord, thereafter this started in a very systemic.
Already. Order.
One fact.
Can I assist you?
No, Mr. Rodgi, we don't need assistance right now at the conclusion of the matter.
One fact.
I am the person who's going to.
Lord, they have no stakes in the matter.
Forget my application.
No, Mr. Rodgi, we will not hear you when your application. We have to follow procedure in the court. It's a constitutional court.
Allow us.
Mr. Rodgi, no, Mr. Rodgi. I told you the reason for it. We are now at a stage when the judgment.
I am not on my application. Not that has become infectious. I am now only saying.
No, Mr. Rodgi, we don't need any assistance at all. We are clear. We had very able assistance on both sides. We don't need any third party assistance.
I didn't get a proper assistance.
So just one
The
thing.
grievance of those who will now be deemed that you have given A party, you have given to B party, that will be.
That was.
Lord, one more clarification.
What we did that we gave to the government under a scheme.
Mr. Rodgi, there's only one simple answer.
Yes.
With effect from the 12th of April 2019, when we directed the collection of all details, everybody was put on notice that hereafter, the details which you furnished would be subject to the result of the petition. Therefore, in drawing the balance, we did not ask for the disclosure of details prior to the interim order of the court. And that was a very conscious and well thought out decision of the Constitution bench.
Was it the intention of the court to know which man paid where, so that if he pays A party, he will be subject to victimization?
Answer is yes.
The answer is yes.
Lord, only one line, my lord. Only one line, my lord. Mr. Bhushan may, my lord, now hold his horse.
Pursuant to your.
He has done, my lord, substantial assistance. I don't have to formally disassociate myself with today's mentioning, my lord. That by disassociating from Mr. Agarwal doesn't mean that I am.
Mr. Solicitor, irrespective of the
Yes, but maybe treated as well.
We must just tell you that we respect this very responsible approach which the Solicitor General has adopted because, clients apart, who you are representing apart.
It is really painful, my lord, when the people before the court start, my lord, a media campaign to embarrass the judges.
Thank you for saying that you don't
very, my lord, painful.
With the mentioning. Thank you for saying that you don't associate.
Because there is no level playing field. I can't hold a press conference.
Only grievance is that it was not a justiciable issue. Yeah, Solicitor General did not raise it. It is not a matter of pure policy. I read the entire judgment. It was entirely a policy issue. It is not justiciable at all. That's all I want to say. The people of this country feel that a decision was taken behind their back. When the parliament decides, they were present in the parliament. It is with their consent. When your lordship decides, we are.
Last order, the election commission has put out the sealed covers, but that's very interesting that those sealed covers show that some of the smaller parties have disclosed the donors.
We don't have to go into all that, Mr. That's not our remit at all.
No, I know.
What has happened after the judgment is not something we are concerned with
Not after
at all.
the judgment. What I'm saying,
now,
what I'm saying is this, that since the order of the.
Very recently, I was asked about a critique on a judgment. I need not mention which judgment. And I said that, look, it's no part of the role of a judge, least of all of a constitutional court or even a civil judge, to defend their views. Once we declare a judgment, it becomes public property. It's the property of the nation. If there is the property of the nation. And,
No, I was only saying that your lordship's interim order of April 2019 asked the political parties to disclose the name of the donor. The information given by the political parties to the Election Commission, only a few of the political parties, the smaller regional political parties, some of them have disclosed.
He is not
the names of
addressing
the
your
donor.
lordships, he is addressing somewhere else. Kindly hear him for some time. So that it comes, my lord, in the newspaper tomorrow, that Mr. Prashant Bhushan vehemently said this. That's the purpose.
Unfortunately, public interest litigation have now become publicity interest litigation.
It is publicity interest litigation. It is, my lord, there are some hidden agendas. There is no doubt, my lord, and I am not, my lord, apologetic in saying.
I am astonished.
And my lord, that is the matter of greatest concern, because judgments given, my lord, for high constitutional principles then are used for purposes other than what they are delivered. Unfortunately,
In your lordship's majesty, would not know, my lord, what are the hidden agendas behind
just dictate a short order. I think, we are unnecessarily expanding upon the remit.
Because the major political parties have not disclosed the donor.
Just give us 2 minutes to
Therefore, what all the time requesting is that the disclosure of the details of the bonds should actually start from the beginning of the issue of the bonds, not just from the interim order, because this is leading to a situation.
1 second, we got the point. You filed an application on that. In our order,
they filed an application.
Mr. Ansari, just 1 moment. Do it in a very cool and calm atmosphere. It's a constitutional adjudication.
Yes.
Right? In our interim order, we said that the disclosure shall be made with effect from the date of the interim order, 12th of April 2019.
Yes.
Right or wrong, we have taken a conscious decision that the cutoff will be the date of our interim order. And we also explain why we took that date. We said after that date, of course, the Constitution Bench has an option to go all the way back from the date of the bond or from the date of the judgment, some place via media in between. We took 12th of April 2019 because it was our considered view of all of us five that once that interim order was pronounced, everybody was on notice, what we told Mr. Rodgi. Now we have maintained that if you want that to go back to 2018, that's in the nature of a review of the judgment.
So the only reason why I'm saying that,
modify that date.
No, the only reason, because your lordship asked the political parties to give donor details to the Election Commission prior to that interim order. And while some of the political parties have given donor details, other political parties have not given donor details. The major political parties have not given donor details. And one political party, which is in power in one of the states, says, if somebody came and left it under our door, 10 crores of electoral bonds was left under our door, we don't know who it was. So therefore I am saying that because this is leading to a situation, though your lordship asked the political parties to disclose donor details by that interim order, only some political
Mr.
parties.
Bhushan, we have understood that argument, but what we are directing was the numbers are given, it will sort out a lot of problems. A lot of your issues will
But for that period of 2018 till April,
we are not sitting in a review. We have taken a conscious decision.
we are faced with a situation where
Mr. Bhushan, this will really be a substantive modification of the judgment. We can't do it like this in a miscellaneous application.
No.
And
in the light of the disclosure which has come to light of the political parties, that's why I'm saying.
And it is not a
if the political parties had disclosed the donor details, this would not be required.
Draw the line somewhere. We had to hold the balance. We've held the balance ultimately.
As your lordship pleases, but I just
Can I just add one sentence? Lordship said all the details, Lordship may consider, my lord. I have pointed out that 6 details may be necessary, my lord. One is the serial number because they say 28,030 bonds have been issued. The second would be the date.
1 second. When you say serial number, you mean the alphanumeric,
Total
right?
number of bonds issued are 28,030. I'm not saying Lordship said all details, not in my respectful submission, it will be.
Mr. Sarve,
no, Lord, Lordship, just permit me a minute.
Sarve has fairly stated that he will all the details. Why?
Yes.
No, my lord, if I can just show.
And data are already disclosed.
What your lordship would say, my lord. I'm just pointing out what details can be there. First is serial number. Second is the date. The third would be alphanumerical number. Fourth column would be name of the donor. Fifth column would be the name of a political party, and sixth column would be the amount. Well, this will cover all the details, not in my respectful submission.
This is now asking us to sit down and collate one.
This is a submission made to the court. Just like Mr. Salve made a submission to the court, I'm making.
Yeah, we need.
Very well, I'm making a submission to the court. Mr. Salve cannot asking us to do whatever. Look,
Please permit the, my lord, the Chief Justice to dictate the order now at least.
Secondly, my lord, the Lordship said, Lordship has seen that IA, my lord. I filed that IA. For a pre-period, if a Lordship have taken a conscious decision on that aspect of the matter, my lord, Lordship may say, my lord, because the order said, my lord, the voters are entitled to know as a right of information. If a Lordship have taken a conscious decision on that matter, my lord, it will be from 12th of April only, because we said, my lord, it should be, my lord. Otherwise, logically, once the right to know, my lord, is inbuilt in the system, in right to know of the voter. Very well, I'll leave it at that.
And there is a specific direction with effect from 12th April.
Then your Lordship said, I have not pressed the application.
So, Bhujan, there will be no end to it.
What is the IA number, Mr. Ansaria? Just 1 second, Mr. Bhujan. IA number which you are not pressing is IA number?
Diary number 12580-2024. Which is MA number, MA diary number.
So that you are not pressing?
Yes, ma'am.
Just
Just
one,
say it, MA
by way
diary
of
number
information on
12580-2024. Mr. Vijay Hansaria, Learned Senior Counsel, appearing on behalf of the applicant, states after some submissions at the bar that the miscellaneous application is not pressed.
In view of whatever proceedings have gone to the court, in view of the proceedings before.
In view of whatever.
If a lot, you can say that.
Otherwise, in view of what? In view, we'll say, in view of the specific directions contained in paragraph 200, in paragraph 219, bracket B and C of the judgment of this court dated 15 February 2024.
Just one fact by way of information.
Enough of assistance by this public spirited person, my lord. Your lordship doesn't need any further assistance.
The details of the number of bonds shown by the, in the data.
He is gathering the details for a future PIL, my lord, so that remains in, he remains relevant.
Now, please permit the, my lord, the Chief Justice to dictate the order.
Heard everybody, Mr.
I was just pointing out that there is a huge mismatch between the number of bonds purchased and the number of bonds encashed in the data submitted by the State Bank to the Election Commission. They are showing 18,871 bonds purchased, but showing 20,421 bonds redeemed. The total amount of bonds purchased is 12,155 crores. And the amount redeemed is 12,769 crores, that is 550 crores more than what were purchased. Now the explanation for this could be because the data is from 12th April. At that time, the bond purchase was going on. On 12th April 2019, it was going on. What is possible is that some of these bonds were purchased prior to 12th April 2019, but redeemed after 12th April 2019, and that is why there is a mismatch. But I just wanted to point out there is a very large mismatch.
There is no, Malad, these figures are not authentic. I've given the authentic
18,000 versus
sponsored NGOs are, my lord, fudging the figures and bringing their own. My lord, your lordships are aware, there is a beautiful, my lord, quotation by Einstein that some people use statistics like a drunken man uses lamp posts more for support than for illumination.
I'm just showing the number. I'm saying that 18,000.
This is what happens.
When now leave it at that.
Those numbers are not right. Since, because all this is going to play out, the numbers are not right. The corrected numbers were not given in our application.
अलग order pass कर देंगे. इसमें MA में ऐसा लिख लीजिए. In subpara B and C of paragraph 221 of the judgment of this court dated 15 February 2024, the direction to the SBI to submit details of bracket 1, the electoral bonds purchased, semicolon, and bracket T2, political parties which have received contributions through electoral bonds, is specifically since the date of the interim order dated 12 April 2019. Stop. In other words, all details which have been directed to be furnished in the operative directions of this court are with reference to the interim order, are on the basis, don't say on the basis of, are with effect from the date of the interim order, namely 12 April 2019. Full stop. The relief which has been sought in the MA for predating the point of disclosure would amount to a substantive modification of the judgment and hence cannot be dealt with in a miscellaneous application. Full stop. The miscellaneous application is therefore not maintainable and is accordingly dismissed.
I want one more relief to prevent another round of contempt proceedings. Would your lordship just for a minute have my affidavit in compliance for it?
What is it that you want clarification?
Yes. Marat, there was, when we gave your lordship, that's why I can see all this story has started. When we gave your lordship the original figure of 22,217 bonds, we had, by mistake, that was from 1st of April, not on 12th of April. If your lordship just sees para 4 and Marat, everything will be over because I know where this is going, where Mr. Bhushan is going. Please see para 4 of my compliance affidavit for 1 second.
Yes.
And please, I would invite your lordship to say, your lordships accept this. We have given the figures, Marat. There is no mismatch, there is nothing of the sort. The total, if your lordship sees the table.
will not go into all that. I mean,
I have to convince my lord I have complied with the order. I'm just saying.
It's a compliance affidavit. It's a compliance affidavit of your chairman and managing director. We have accepted that.
Please say your lordships have accepted our compliance affidavit. That will put an end to all this.
By the judgment of this court dated 15 February 2024. This court directed into inverted commas
it will come under my submission. It will be a fermentation industry other than portable alcohol. It will come under ND 26 directly. Because if it's fermentation industry with portable alcohol, you're out of the amended 26. So you could have a situation where the raw material, what they call the substrate is still molasses. Molasses will be converted into alcohol, but that alcohol is never diverted for human consumption. Straight, it's an integrated process, start to finish. You put molasses here, you get MEG outside. It will be an industry based on fermentation. 26 will, that's my submission.
No, but I thought what fell from your lordships is something slightly different.
I think
lordships were thinking about a case where part of the alcohol goes into potable purposes and part of the ENA goes.
No. The whole of the alcohol goes for conversion into a final product.
The good test is what is the final product of this unit? If the final product is MEG, then.
But if it's a
suppose it is a dedicated industry.
Yes.
For producing MEG.
Yes.
Then it will have a different understanding.
Yes.
But suppose it is starting off as a, what is that, extra neutral alcohol producing, and then eventually subject to demand, let us say, you are in that industry, extra neutral alcohol, you are up till the state is still then in control. Thereafter, depending upon how, at the point of removal, what extent you are removing, then state and union control will come in. That's what I think Justice Jiban Reddy had said.
Yes. But your lordship, the answer is, in your lordship's example, my final product will say ENA, extra neutral alcohol.
Your final product will say.
My license will say extra neutral alcohol. I have to get permission from the state distillery.
Right.
But if I'm going to make MEG or if I'm going to make alcohol-based final products, because there's a host of final products which can be based out of alcohol, then I will go for an excise license or now a GST license, and I will never come within the purview of the state law because I'm never making ENA at all. I'm never clearing ENA.
That time you are adding the denatured elements.
Yes, there my final product is potable alcohol.
Correct.
That's why what they say is intoxicating liquor is intoxicating liquor. To the extent you denature it, it doesn't cease to be intoxicating. It becomes unfit for human consumption.
That is a little area of
that's the area I'm
little
not
area of
confirmed.
divergence between you and Mr. Giri's.
Yes, Lord, I would still stick to the submission, Lord, with respect.
Yes, yes.
Yes. Lord, para 3 of
But only thing,
subpara-
Lord, we both say I'm under state control.
that's
So we are denatured. Here I'm under state under entry 8. He's under state in entry 33. But your lordship's answer is correct. If the center is notified, then under Mr. Giri's argument, denatured will come under central control.
Right.
Under 18G.
Yes.
Lord, subpara 3 of para 23 of Bihar distilleries deals with this aspect. I think when your lordship said integrated, your lordships had in mind a case where up to the stage of production of extra neutral alcohol, Lord, there is no divergence. But after ENA comes into being, part of it is may not diverted for an industrial purpose, either by denaturing it or may not for whatever the process, it has to be denatured. It then becomes industrial alcohol. Justice Jeevan Reddy's judgment, my lord, also speaks about a case where without denaturing it, it is still treated as industrial alcohol because it is not meant for potable purposes at all. In my respectful submission, since ENA is also, my lord, alcohol, which would come under entry 8, it is not inconceivable, my lord, that the state may come out with a, my lord, like in, my lord, intermediate products could also be subject, my lord, to an excise duty or a levy. And therefore, ENA is an intermediate product and not the final product as such. ENA could be subjected to. But where the ENA goes into the manufacture of potable alcohol, I don't subject it to an excise duty at the stage of ENA. I'll probably reserve my right to do it after the final product comes out. But why should I lose out? Why should the state lose out if the control comes under entry 8 and it says production, manufacture? Manufacture is always will not conceive of the final product. Production is of an intermediate stage. And if therefore extra neutral alcohol, even if it is 95% as mentioned in para 74 of synthetics and chemicals, is still a product which is covered by entry 8. I would not by lose my right, not even under entry 8, to tax it before it is cleared, my lord, for industrial purposes. Therefore, my lord, this is my respectful submission. To that extent, subpara 3 or the paragraph 23 may be, my lord, modified by your, in Bihar distilleries also should be modified by your lordships. It's my respectful submission. My lord, just one more aspect, my lord, and I'll complete it. In synthetics and chemicals, my lord, and why? Synthetics. This may move on synthetics and chemicals. synthetics and chemicals, my lord. I'll complete my submissions. Synthetics and chemicals is 1991 SEC, page 1. 1990, page 1 SEC. Give the citation for synthetics and chemicals. 109. My lord, it's in volume 5, page 9, PDF page 9. My lord, lordships may come to paragraph 74 at PDF page 54. I don't want paragraph 41. I'm going to Lord, the objectionable portion, my lord, if I may say so with respect.
Page 50.
PDF page 54, paragraph 74. My lord's got it. Ladyship has it?
Yes.
It has to be borne in mind that by common standards, ethyl alcohol, which is 95%, is an industrial alcohol. This, my lord, we would respectfully submit. We would most respectfully urge requires reconsideration. Why, Lord? Why should it be questioned, which I ask unto myself is, why should it be treated as an industrial alcohol? It's extra neutral alcohol with a higher strength. It can be used for human consumption. Of course, my lord, by tempering it with water or by any other substance as such. But there is no question of, my lord, it becoming irretrievably unfit for human consumption. That happens only on denaturing. Petitioners and the appellants were manufacturing ethyl alcohol, also known as rectified spirit, fair enough, which is an industrial alcohol. My lord, that doesn't go as a sequit. ISI specification has divided ethyl alcohol into several kinds of alcohol. Beverage and industrial alcohols are clearly and differently treated. Rectified spirit for industrial purposes is defined as spirit purified by distillation having a strength not less than 95% of volume by ethyl alcohol. Dictionaries and technical books would show that rectified spirit is an industrial alcohol and is not potable as such. But then where is a reference, my lord, to the legislations which were existing from 1880 onwards? It appears therefore that industrial alcohol, which is ethyl alcohol, by itself is not only non-potable but is highly toxic. The range of spirits of potable alcohol is from country spirit to whiskey, and ethyl alcohol content varies between 19 to 43%. These standards are according to the ISA specifications. In other words, ethyl alcohol 95% is not alcoholic liquor for human consumption, but can be used as raw material input after processing and substantial dilution in the production of whiskey, gin, country liquor, etc. Entry 8 relates to production also. My lord, why should ethyl alcohol at 95%, which is one of the raw materials, or which is used as a base for preparing different varieties of Indian-made foreign liquor or country liquor for that matter, where only there is a dilution by addition of water, why should it fall outside the purview of alcoholic liquor for human consumption as mentioned in entry 8? Can be used as a raw material input after processing and substantial dilution in the production of whiskey, gin, country liquor, etc. In many decisions, it was held that rectified spirit is not alcohol fit for human consumption. Reference may be made in this connection to so and so, so and so. In this connection, it is important to bear in mind the actual provision of entry 8 of list 2. Entry 8 of list 2 cannot support a tax. The above entry contains the word intoxicating liquor. The meaning of the expression intoxicating liquor has been rightly interpreted by the Bombay High Court in Balsara. The decision of the Bombay High Court is reported in so and so. In that light, perhaps, the observation of Justice Fazal Ali in Balsara's case requires reconsideration. It appears that in the light of the new experience and development, it is necessary to state that intoxicating liquor must mean liquor which is consumable by human being as it is and as such. When the word liquor was used by Justice Fazal Ali, they did not have the awareness of full use of alcohol as industrial alcohol. The point is not that, the boot is on the other foot. Can it be used as potable liquor? It is true that alcohol was used for industrial purposes then also, but the full potentiality of that user was not then comprehended or understood. With the passage of time, meanings do not change, but new experiences give new color to the meaning. In Harshankar's case, A bench of 5 judges have surveyed the previous authorities. That case dealt with the auction of the right to sell portable liquor. The position laid down in that case was that the state had the exclusive privilege or right of manufacturing and selling liquor, and it had the power to hold public auctions for granting the right or privilege to sell liquor, and that traditionally intoxicating liquors were the subject matters of state monopoly, and that there was no fundamental right in the citizen to carry on trade or business in liquor. All the authorities from Kuvarji Barucha to Harshankar dealt with the problems or disputes arising in connection with the sale, auction, licensing or use of portable liquor. Now, my lord, in para 77, Article 47 of the Constitution imposes upon the state the duty to endeavor to bring about a prohibition of the consumption except for medicinal purpose of intoxicating drinks and products which are injurious to health. If the meaning of the expression intoxicating liquor is taken in the wide sense adopted in Balsara's case, it would lead to an anomalous result. Does Article 47 oblige the state to prohibit even such industries as are licensed under the IDR Act but which manufacture industrial alcohol? This was never intended by the above judgments of the Constitution. It appears to us that the decision in Synthetics and Chemicals Limited, the first one, was not correct on this aspect. Then, my lords, please come to paragraph 81, the conclusion, 81 onwards, lords. It is not necessary for us here to say anything on the impose on portable alcohol as commonly understood. These are justified by the list of our legislature practice in this country. See the observations of Justice Hidayatullah as the Chief Justice then was in Guruswamy. In that view of the matter, it appears to us that the relevant provisions of the UP Act, AP Act, Tamil Nadu Act, Bombay Prohibition Act, as mentioned herein before, are unconstitutional insofar as these purport to levy a tax or charge imposed upon industrial alcohol, namely alcohol used and usable for industrial purposes. This is where the shoe pinches for us. In our respectful submission, this would be correct. Para 82 could be affirmed if instead of industrial alcohol, it is used as denatured spirit. But if, since in para 74, the lordships have synonymously used industrial alcohol and rectified spirit would be 95% ENA, my lord, this would be incorrect, my lord, in my most humble, respectful submission.
Well, arriving at this conclusion in paragraph 82, there must have been a discussion on the content of entry 8, list 2.
There was.
On the scope and ambit of that.
Para 41, my lord, contains that.
It's at the bottom of 74.
Para 74. I have read. I have read para 74. 67. Yes, my lord. Could your lordships have a look at para 41 and then 67? There is a reference to para 41. There is a reference to it in para 41. That is a PDF page 37.
So according to in para 82, instead of industrial alcohol, if you were to read the word denatured spirit,
that's it.
That would solve the
suffice. That would suffice. Lord, your ladyship was asking about the discussion.
Which para were you saying, Mr. Giri? 44, is it?
41. 41. 41 at PDF page 37. The question was formulated, but thereafter, my lord, I think it went into. The only question which has to be determined is whether intoxicating liquor in entry 8 in list 2 is confined to portable liquor or includes all liquors. According to the Union of India, in view of the difference of language in entry 8 and entry 51 of list 2, it is reasonable reasonably possible to take the view that intoxicating liquors include both liquors. It was submitted by the Union of India that there are no grounds for overruling Balsara, decided in 51 after 38 years, particularly when it has been followed and applied in later decisions. In that case, it upheld the power of the states to completely prohibit, manufacture, sell, etc. potable liquor. It struck down the provisions of the Bombay Act insofar as it imposed restrictions on medicinal and toilet preparations as violative of 19(1)(f) of the Constitution. It is stated that this decision had proceeded on the basis that there could not be a complete prohibition in regard to medicinal preparations containing alcohol. Hence, it was submitted that so far as alcohol not fit for human consumption is concerned, it cannot be held that trade in such an article cannot be considered to be a noxious trade. It will be a noxious trade only where it is produced or manufactured for purposes of human consumption. It is submitted that Indian mica and micanite industries versus State of Bihar. This court was dealing with denatured spirit and had held that Bihar Odisha Excise Act, insofar as it related to denatured spirit, was regulating trade and business in public interest, and that entry 8 of list 2 comprehends all liquors containing alcohol. The state's privilege to completely prohibit or farm out liquor containing alcohol for human consumption does not comprehend, according to the Union of India, a similar right of a state with regard to other intoxicating liquids containing alcohol. According to the Union of India, to so prohibit or collect fee for farming out would be unconstitutional under 19(1)(g) of the Constitution, on the same principle on which the provisions of the Bombay Act were struck down in Balsara. It was further stated on behalf of the Union of India that Parliament has legislative competence with regard to power alcohol, providing for levy of central excise duty. See the central excise, but the discussion remains unconclusive in 41. Mr. Dwivedi says 67, 74 I have already read. 74 I have already read out to your options. In my respectful submission, alcohol fit for in entry 8. Is intoxicating liquor would take in, my lord, everything other than denatured spirit in entry 8. And therefore it would take an extra neutral alcohol also, rectified spirit. Lord, the rest of the areas have been covered.
Thank you, Mr. Giri. Thank you.
Grateful to your lordships. Deeply grateful.
It's actually
Yeah, please. I'm appearing for state of Maharashtra.
We have to only do it on the basis of understanding.
Well, the common thread in 246, 1, 2, and 3 is the subject matter enumerated in these three lists. If the subject matter is not same so far as the list 1 and list 2 are concerned, then there is no fight between these two entries, and state and union can respectively enact the laws based on the subject matters enumerated therein. If we carefully look at the entries given in both, the matters can be in the nature of activities, places, larger concept like industries. And particularly if we look at the present case, the entry 8 in list 2 is a product specific subject which is there, which is intoxicating liquors. If the intoxicating liquors is a product based subject matter based on which the state is competent to make law, whether the entry given in list 1, 52, which is an entry pertaining to industries, and industries also subject to qualification, union to make law, to take control. So therefore, this being debated in these judgments, whether the entry 52 per se is law making enabling entry, or thereafter the until unless law is made, the competence is not driven. But I'll come to that part, Manoj. If I'm able to satisfy that the industry, the subject matter based on which the IRDA was made in 1951, till 1956, the alcohol was not the component of the schedule which is being given therein. And more interestingly, alcohol is not the declared industry there. Fermentation industry is the declared industry, which has got 2 products in that. Similarly, if we look at the chemical industry, it has got 15 or 16 products. If you look at the steel industry, it has got the 16 and 17 products. So, my first submission is that when we closely read the entry, and that has survived since last 75 years now, this is my respectful submission. A product-based legislation which has been made pre-constitution time also, those are the state excise laws, and then the subsequent rules which are there. All the provisions in these acts pertains to industrial alcohol or, the intoxicating alcohol. There can be different stages. There can be different activities which are pertaining to those products. And in order to regulate and control, a different procedure has been prescribed in states. Nowhere Industrial Development Act has dealt with what is being dealt with the acts which we are talking of, state laws. There can be a difference between the industrial license and there can be a difference between the product license. At the industry level, the governance and regulation can be different, which stems from the provisions of the Industrial Development Act. At a product level, the regulation and governance can be different, which stems from these excise laws. Neither union at any stage made an attempt that we want to govern a product and therefore we'll specify that how alcohol is to be manufactured, stored, moved, removed, and to be denatured, renatured. Nothing has been dealt with. Our declaration in section 2 of the Industrial Development Act very clearly says, union wants to take a control of the industries given in the schedule. Nothing more, nothing less. If we see the index of the entire Industrial Development Act, that talks of the councils to be framed. Councils are going to guide that how the production of the country to be increased. Subsequent chapter says that how the ownership is to be looked into. After a particular date, the industries are existing, industrial license is to be taken. And 18G is the only one category, and that's also not the category is unconditioned. That says if the union think it is to be determined fair price, it is to be distributed in a particular manner, then under 18G some category is to be, some notification is issued to be certified product ones. Now, to look at this, is there a conflict between entry 52 and entry 8 if we look it from the point of view And whether in last 75 years, at any point, at any stage, the issue has arisen in this context, the answer with great respect is no. Today, there is no law made by union, and that's the reason para 41 of the synthetic, union agreed to this position, saying that both the products are covered in entry 8. That was the basis if we read para 41. So it is not that there is no basis of para 41, and today union says that no, my position is that so far as denatured spirit or industrial alcohol is covered is in the union list. That's not the issue. To make this submission good, I'll rely on I could mail it in the morning, but I'll give a gist of this case. Vijay Kumar Sharma, this is 1992 SCC 562.
Submission?
1990.
I'm sorry, 1990.
Can you just formulate the submission? Because
Yes.
what is exactly
My submission is this, Malas.
Yes.
That entry 8 on a standalone basis, dealing with intoxicating alcohols, give power to the state government to make laws on it, and there is no conflict with the entry 52 in list 1, Malas. Because entry 52 list 1 deals with the subject matter pertaining to industries given in schedule 1, which is an industry based legislative competence to be seen. Whereas in the list 8, entry 8 list 2, the product based legislative matter is provided, which is to be seen in 246, 1, 2 and 3, Malas. And this issue came before one of the constitutional benches, and the test prescribed was whether the subject is same in both. And if I'm able to satisfy, and my lords are with me.
What is the industry?
Yes.
The product in this respect, the product is a product of an industry.
Yes, Malas.
Which is declared under entry 52. Then what happens?
Malas, if the industry per se, and I'm grateful, Malas, and that's the reason why this debate came, that what is the industry means and why it was in these two judgments specifically restricted, it's to manufacture and not pre-manufacture, not post-manufacture. So the industry per se, Malas, if we look at it, even if the product is given, and if we look at the law which has been framed, a law which has been framed is not at the product level which has been framed, which is framed under the entry 8 in these in the state subjects, or in the state laws. Now the industry to be seen for the purpose, even if the product, one of the product is given.
Industry is fermentation.
Industry is fermentation. And what are the laws which can be made about the industry are, and which are very, very clearly enumerated in the act itself of the Industrial Development Act. And if we'll see the amendment in 2016, precisely give the reason, say that under the 1951 Act, we have to look at the policy to be made in regard to the industries which are enumerated in Schedule 1, not regarding the product. There is not even a single provision in the Act which deals with the a particular product, how the product is to be regulated. That's not the provision which has been there. The judgment which I'm referring to, I'll just quickly give a background. And if we see, the entry 52 in list 1, the industry which is to be seen, is not an independent entry, a law to be framed by Parliament for a reason, to take control. That's a law which is to be framed in terms of the entry. It's not straight away saying that the law can be made and therefore any industry can be prescribed in this. So there has to be law specifying to take control of that particular industry, which is this particular Act of 1951 is. So it's not an open-ended power or legislative competence which can be driven out of this entry. Whereas if we look at entry 8, it is neither subject to any other entry. It is clear open power which is given to state. State, since pre-independence, there are multiple the excise laws which are prevailing, which has been amended thereafter and has been sustained over a period of time. I'll come to the synthetic part.
And under entry 8, according to you, what stages can the state regulate? At what point does it cross entry 8, and what is comprehended in entry 8?
Yes, yes, I'm grateful. Plus, thankfully, like the entry 27 and 28, where gas and gas works is given. Entry 8 has taken care of trade and commerce in that particular product also. If we see
Entry 33.
no, Malazi, for the time being, I'm not coming third. Kindly see entry 8 again with me, Malazi, for a minute. Because one of the angle in the industry.
So it says, that is to say.
Yes.
Production, supply, distribution.
Yes. So if I, for understanding purposes, say what does a trade commerce means, Malazi? Trade commerce potentially can mean the production, manufacture, possession, transport, purchase, and sale. And purchase is an interesting entry in entry 8 itself of list 2, Malazi. Kindly see intoxicating liquors, that is to say production, manufacture, possession, transport, purchase and sale of intoxicating liquor. Any activity which pertains to this particular product, and there is a reason behind it why this has been prescribed like this. My lords are aware and is being debated in last 2 days. Industries are primarily given under entry 24 in list 2. That's the principal entry for industries. There are 2 slices in that. The first slice was the one which I'm talking of, entry 8, on the same day when the constitution was made. Second slice which has been made is out of leftover entry of 24, and the entry 51 was carved out thereafter. And so far as this very product, intoxicating liquor, is concerned, that was sliced out in the beginning itself in the form of entry 8. This was not available in 24 anymore. And therefore, till 1956, till the time the fermentation industry was not the part of the industry declared there, and the alcohol being there, this was not a debate. And that is the reason when we see, I'll show the provision of both the acts, the State Act as well as the Union Act, and the declaration which has been given. That slice which has been carved out in entry 8 is not available in entry 51 is my respectful submission, and that's a discussion. In one of the McDowell judgment, this was precisely the argument Sorabji made before the court, which was accepted by the court. I'll show that argument. Sorry, 52 minutes. 52. So that's once that position is taken. And do we really need to trace the originals? And today we are seeing in the capacity of resolving a dispute. I'll urge and request my lords to see that if it is to be framed today, why
will intoxicating liquor in your submission include denatured alcohol also?
Yes, Malaz, I'll give my reasons to that also. First of all, I can straight come to that, Malaz. And why do we need to split it? 8 is intoxicating liquors. It is the plural. There was no need to use this. And there is why this is being done is because
but then if they wanted to include denatured alcohol, they would have used the expression liquors. Why did they use the word intoxicating?
So it's because the content of alcohol is a measure of a product which is liquor which is to come out. That what is the alcoholic strength of a particular product is going to be determinative factor that whether it is intoxicating or not. Intoxication, a percentage can vary, the composition of a product can vary, and therefore the intoxicating word is used because the liquor primarily, that's what the understanding is in my respectful submission. There is some debate on this. And why this the other product which is denatured is not carved out of this is because all the stages.
What is meant by intoxicating?
Well, the intoxicating certainly means that if it has ability to manipulate the senses of a consumer. Right. So in that case, and that can be in how it is consumed, at what stage consumed can be debatable. But to get into a scientific measure to determine that the intoxication, not in the common understanding to be seen and we need to derive with great respect, may not be the reason. The answer seems to be in the entry itself. Denatured spirit may arise at some stage of all the activities which are given therein. It may be at a production stage, it may be a manufacturer stage, it may be a possession stage, a transportation stage. Wherever the makers thought it fit that we have to give a taxing power, it linked with the human consumption. Like in opium, if we see, opium regulation is given in the union list, but taxing entry is given in the state list. So, in a federal structure, the understanding was that these units can operate on their own. The states can operate on their own from the terms of the financial resources, from the law and order situation, and therefore these were carved out. That the regulatory requirements so far as anything coming out of entry 8, which may have a law and order situation, because of alcohol, because we have seen the numerous cases and some coded distillery and all they have raised, that is the social issue and so on and so forth. And there is some requirement of a society order to be maintained. It has been, the governance has been given to the state. And union has been given to power because there's a revenue calculation for whatever may be the reason. For human consumption, excise duty is there. Sales tax, entry tax, GST, today's state can do that. But after 101st Amendment, there is no restraint except the restraint on the excise duty. That part is there. Now to say that we'll read entry 52 and where the law has been framed to take control, it is not an open-ended entry to say that 52 means the union can do anything with a particular industry. It is only with the objective that the control is to be taken. And that's what we see section 11 and 12 of Industrial Development Regulation Act. They say after this, the particular date, the industrial license is to be taken because union wants to, today, how much FDI to come into it. That's the precise reason given in their objective, saying that how much of production of this particular product should be carried out in India, what should be the land size, what should be the capital size, a foreign investment permitted or not, who should be the owner, which industry can be taken control of. That can be very one. As a matter of fact, that has been done by that law. And supposing
You have referred to 246 to say that these lists operate on various subjects.
Matters, yes. Yes. Kindly see 246(1) for a minute.
Yes.
Anything, notwithstanding anything contained in clause 2(3), Parliament has exclusive power to make laws with respect to any of the matters enumerated.
As far as entry 8 is concerned,
yes,
it is a product-based enumeration.
Yes, Manas.
And the term intoxicating liquor is used twice in entry 8.
Please, Manas.
So there has to be given some meaning and understanding that it's a product-based entry.
Please, Manas.
And so far as the industry itself is concerned,
yes,
you are talking about the IDEA Act,
yes,
where it talks about that it is expedient in public interest that union should take under its control industry specified in the first schedule.
Absolutely.
So you are trying to make a distinction that when you take over industries,
yes,
it may have nothing to do with a particular product unless it is said that this particular industry and this particular product. Of course, the schedule to some extent gives a...
Yes, it gives a pointer, and then 18G, Manas. 18G specifically says wherever a particular product for some reason is to be regulated, 18G is a power which is being given to the state. It's not that merely because a product related regulation has been given in entry 8, that by virtue of the law framed by virtue of entry 52 state union is denuded. No, 18G is a power which can be given. And why I'm saying is today we have experience of 75 years. If we see what the law says with the Industrial Development Act says, wherever it has been, and 18G also is not independent. When we read, there is a reason behind 18G. It has survived. Today, if we see the referral order, the start point is a paint manufacturer in UP said, I want to buy a denatured spirit. I've been asked to take a form FL41. And he says, I have nothing to do with it. I don't want form for them. Therefore, the law is not applicable to me. That's the start point. Now, all paint manufacturers, all the consumers of denatured spirit are today in one way or the other required to have some kind of a control in possession, use, and therefore need to confirm back that the actual use being there. And the answer is very simple. excise duty on alcoholic human consumption liquor is 350% in state of Maharashtra. If today denatured spirit for some reason can be renatured, can be converted to consumable, and I'll show that the BIS standards which are there, which can be done, then there is no 350% which is to be paid. So and these are instances after instances which has been taken note of by the state, and the notices have been issued to this, beside the tragedies which are there because there is a methyl alcohol is being used instead of ethyl alcohol in those cases, is being there. So straight away the answer is that if the state is not going to regulate that, and if the alcohol industry, if I say that the particularly treated as industry, the word is alcohol in the fermentation process, a control is given to union with the law we have in place, what happened to those kind of positions which as a matter of fact has been recorded? And that was the very precise basis of aim and object what Mr. Datar read for 2016 amendment. That was the reason. They said we are making this where the human consumption has been taken out of that in spite of whatever the law laid down till 2016. And the reasoning given in the last para is very clear. We want to have a policy control in this, which through the IRDA, which has been done. And never in last 75 years, any attempt has been made to say that the particular industry in a particular state, we want to regulate, control the possession and manufacturing, everything. Not been done. Except these two judgments where say the question came, the industry means what? And there also, it was restricted that because entry 92 talks of control by the union. And the provisions of IRDA give some sense and link with this control by union to the manufacture and production. Because Government of India want to have an overall view that a particular commodity, how the steel is manufactured in India, how much steel consumption is available in India, how much import should be permitted in India, how much of foreign investment should be permitted in India. That can be done through IRDA. But somebody say that each steel product specification should be regulated. We have BIS standards, Standard of Weights Measures Act, and the multiple other laws are there. And particularly when we look at the industry which has been given in the schedule, industry has got 17 products. Assuming one product is given herein. And the subject matter based on places, activity are not new. If we look at 5 and 6, ammunition manufacturing, firearm manufacturing, that has been given to the union in list 5 and list 6. This is the way it has been structured. Now to say, we will not look at list 8, because it's an industry of alcohol, although it's industry of alcohol is nothing there, it's a fermentation industry which has been declared, which has a component of alcohol or product of alcohol in that. It is not the object. The alcohol word written therein and every species of alcohol get covered and therefore the state is taken out. With great respect, that's not the purpose. And I'll give a facts of this Vijay Kumar, which I'm saying, Malaj.
In 18G, actually 18G,
yes, sir.
The IDRA can be partly traceable to entry 52 of list 1.
Please.
Some provisions may be traceable to entry 33 of list 3 also.
Yes.
That's perfectly permissible to Parliament. So when Parliament says you must have a registration of the establishment, licensing, power to take over management, that is Parliament's power of control, which you find in the first few sections of the Act. If you just look at, if you look at the index to the Act,
yes,
it'll say Chapter 3, Regulation of Scheduled Industries, registration.
Yes.
Revocation of registration, licensing, license of producing.
Yes.
Power of central government to specify requirements, revocation and amendment of licenses.
Yes.
Power to investigate into the affairs of a company in liquidation. Then comes Chapter 3A.
Yes.
Direct management or control of industrial undertakings by central government in certain cases. Chapter 3AA, management or control.
Yes.
Power to provide relief to certain industrial undertakings.
Yes.
3AC, liquidation or reconstruction of companies.
Yes.
Right? Up to there,
yes,
it may be traceable to entry 52 of list 1.
Yes.
Now, when it comes to Chapter 3B,
yes,
control of supply, distribution, price, etc. of certain articles, 18G is what we are concerned with.
Yes.
That is referable to entry 33 of list 3, except that entry 33 also covers production. Entry 33 covers production, supply, distribution. Section 18G doesn't cover production. It only covers trade, commerce, supply, and distribution.
And reason is very obvious,
right. Therefore, 18G is Parliament's in exercise of Parliament's power under entry 33 of list 3, right?
Please.
Now, therefore, conceivably, Parliament can control trade or commerce in. And though you are saying that IDRA is industry based and entry 8 is product based, the section 18G is product based.
Yes, I'll come to the 18.
Certain articles,
yes.
which
As
are
of today-
which are referred to in the schedule.
Yes.
So, in relation to 18G, the IDRA also becomes product based. The point which is, however, made by the others, by the lawyers who appeared before you, was of some weight, which is that 18G will come into existence, will apply provided there's a notified order.
Please, ma'am.
Until date, the union government has never made a notified
That's
order.
Tikaram Ji,
Right?
Yes.
So, but short of that, for us to say that article entry 8 will cover all kinds of alcohol, irrespective of whether it is denatured, otherwise, would be a little extreme. It would be maybe a very extreme view of entry 8. The better view may possibly be, subject to hearing the other side, that entry 8 will not cover
Yes, certainly. That's my argument, which I'm
denatured spirit.
Yes, well, I'll come to that part. If we see entry 33 also doesn't deal with the industry, deal with the products.
And theoretically, Parliament, once it notifies an industry as declares an industry to be a controlled industry,
yes,
it can even deal with the articles of that industry. It has a power then to deal even with the products. Question is whether Parliament delegate, that is, the central government has done so. So long as it doesn't do so, the power is still with the states under entry 33.
Kindly see 18G with me for a minute.
Except in relation to denatured spirit. On denatured spirit,
yes,
the state's power may be restricted.
Well, I'll try and persuade my lords. Kindly see, first of all, my lords are saying by virtue of 18G, product-specific power also come to.
But even on denatured spirit, the state's power may arise under entry 33. That's not a fiscal entry.
Yes. So if
right, even in regard to denatured spirit,
yes,
which goes into entry 52,
yes,
the states still have a regulatory power under entry 33.
Yes.
For instance, they can ensure against diversion. They can lay down various regulatory norms. The state is, and for that purpose, it may demand a fee.
Yes, that certainly can be done, Melissa. I have no difficulty on that part, Melissa.
So what is your wider submission? From what everybody else has argued, what is it? Because
my wider submission is that that so far as entry 24 is concerned, which pertains to list 2 industry, the industry is in the state list. A carve out is 7 and 52 of list 1.
Right.
Whereas if entry 8 is to be seen, which was existing right from the day 1 in the constitution, that as a matter of fact, along with the trade and commerce, what we call it, possession, sale, control, and purchase is only in that entry. Purchase is nowhere else. The reason for that is that if any controlled commodity is to be purchased like by the paint industry, in that case, the FL 41 can be asked for under the state law. And that's why the word purchase is there. In no other entry, the word purchase is there. It's only in entry 8. But having said that,
there's one thing. I mean, what is Maharashtra's? What's the submission actually?
Well, my submission is one: the state, as a state of Maharashtra, we are competent to make the law which we have made and which we, as on today, are exercising. That the denatured spirit is covered under the entry 8 of list 2. That's my submission. And the reason for that is twofold. One is a standalone list 8 gives the state power. And IRDA, by virtue of entry 52, is not overstepping that domain. That's my first argument. Second argument is, even if you
state can make law on denatured spirit.
Yes, Manoj. By virtue of same being part of intoxicating liquors, Manoj.
That is Mr. Dwivedi's submission also.
Yes, originally Mr. Dwivedi.
Relying on Balsara.
Yes, Balsara. Second submission is, well, it's that entry 51, entry 52 of list 1 is not a unblocked entry. It is blocked and a specific purpose controlled by union of an industry, a law is to be made, which is IRDA.
Not, what do you,
I'm sorry. The
not an unblocked entry, what do you mean? by
Yes, unblocked means it's not an unbridled power that in regard to any industry, the union can make. That power is in 24. Union need to make a law to take control of that industry, the law pertaining to take control, and that's section 2 declaration of the IRDA, my lords. If I can read quickly the entry itself, my lords have seen on numerous occasions. Industry, the control of which by union is declared by parliament. It is not simply considered industry.
Right.
And otherwise, the industry is covered under entry 24 of list 2, Malas.
That is the point. What is the nature of industry under which the center parliament can make?
Yes, Malas.
You have rightly said fermentation industries.
Yes.
Even if you see this 26 fermentation industry, there is a twofold classification.
Yes, Malas.
One, it is alcohol. The other is
Others.
other products of fermentation industry. So, under alcohol, they have again made a classification. Alcohol which is potable,
Yes.
alcohol which is not potable.
Yes, Malas.
That means it's an indication
Yes.
that alcohol is potable only is under entry 8.
Malas, the
Anything not potable,
yes.
the parliament has the powers in view of entry 52 list 1 and entry 24 of list 2.
My respectful submission, Malas, even if we look at that indication sum which has been given, if it is an industry specific and a product which has been already given entry 8, will that entry given in that schedule will exclude one of the product out of the product which has been given in entry 8? With great respect, and
It is not the product, it is a classification of a product.
this is the subject matter. The subject matter of framing law.
But then, Mr. Balbir Singh, your submission is not at variance with what Mr. Datar or Mr. Dwivedi argued. Because their contention also was that denatured spirit also falls in entry 8, step 1.
Yes.
Because it falls in step 8, in entry 8, it can't fall in entry 24.
Yes.
Right?
Yes.
Because following Calcutta gas.
Yes.
If it can't fall in entry 24, there's no question of it being taken out for the purpose of entry 52.
Yes.
Right? That was the line going from entry 8 to entry 24 to entry 52. And therefore, according to them, this retains the power of the state under entry 8.
Yes.
So your submission is not different from that.
Effectively not different, but I'm trying to take maybe a step prior to that.
Content of entry 8.
Intoxicatedly.
So I'm only on the subject matter, Malas. I'll just rely on 2 judgments.
I think that, while entry 8 is product based, entry 52 is industry based.
Industry based, Malas. And today
there's an answer to it that, entry, IDRA is both product based and industry based. In section 18G, it's product based. There are some parts of it which are industry based, of course.
Today, when we look at the declaration which is given in section 2, the similar declaration, I can quickly tell the facts of this case before in Karnataka, the contract carriage was nationalized. In 1976, law was framed and all private contract carriage was taken control of by the government by a law. This was in 1976, went to Supreme Court. Supreme Court identified 7 judges before this court, and court said that state is competent, identified the entry with the acquisition and requisition entry in entry 42 in concurrent list. Not tracing to industry, but tracing to saying that the acquisition of property or acquisition of property in 42 is there. 1988 Motor Vehicle Act came in. One of the parties went to the state authority RTO saying that now the 1988 Motor Vehicle Act has come, please give me the registration or license. This issue came to the Honorable Court again. There the issue came that 1988 a Central Act has come in, and therefore these provisions are in conflict. Looking at this provision, and the Motor Vehicle Act was also traced to entry 35 of concurrent list. So both the conflicting entries were in the state list. This Honorable Court said that just to explain, the entry 35 was pertaining to mechanical vehicles. So therefore, 2 conflicting entries were requisition and acquisition of property and mechanical vehicle. These were 2 conflicting entries for Motor Vehicle Act of 1988 and 1970, the acquisition law. This Honorable Court said, if the subject matter is not the same, even if there is an overlap, then they independently they can prevail. Maharaj. Today, to oust the jurisdiction of the state by carving out the denatured alcohol out of entry 8, relying on a schedule, a product given a schedule with respect, Maharaj, this is an independent subject. There the industry has been defined. That's what he argues.
No, I think we'll conclude at this point. We'll take Mr. Faraswat. Yes, Mr. Faraswat. Thank you, Mr. Baldi.
Well, just one part I want to read. From the IS, Mr. Giri argued that so far as the state of Kerala is concerned, that the denatured cannot be converted to renatured. BIS standard, which in para 74, which we looked into in synthetics, simply said anything over 95% is industrial alcohol, although it should be denatured. This was taken note of by BIS standards. I have placed on record. I'll give the page numbers also. They clearly noted that there can be a complete denaturing, there can be a special denaturing. As a matter of fact, where the government has faced a problem is special denaturing, which can be again converted into renaturing, because this was specified for some 25 industries. And there are live experiences that has been converted and sold in the market as a country liquor. Based on that finding, it has been given that the BIS standard which are given is in straight conflict with para 74. That's been a forward which has been by BIS which has been given. So therefore, Mr. Datar pointed out,
in the case of a special denaturing,
yes,
capable of being used again, is capable of being renatured.
Yes, and it's only boiling point is to be changed. They note that it's a very simple process, and they specify also industry. If my laws permit, I can quickly show that BIS standards which are prescribed this. And as a matter of fact, they said it's been happening. And they specified even what is the boiling point and what the change is going to take place, Malas. I just quickly show Malas only one page and then I'm done with that, Malas. Malas, I filed my written submission in volume IK, Malas. And 1K, sorry. And page 129, Malas, which is PDF 129. PDF 130, Malas.
BIS standard. What are you referring to?
Malas, I'm referring to only the forward of those standards where this problem was specifically noted and what is the...
Where do we get it? Where do we get it? Volume?
Volume 1K, PDF 130, Malas, 130.
Say, now it's not there.
Malas, I can quickly read that, Malas. There's only 2 paras. I can just quickly read. The third para, Malas, completely denatured alcohol, which is CD, and specially denatured alcohol ST formulations are set out in this standard with a specific composition. Both CD and ST formulations are made from the spirit in accordance with the international trade practices. These resulting products are not fit for human consumption. Instead, the products are intended for industrial use. CD, that is completely denatured alcohol, is composed of alcohol and specified denaturants that cannot be easily removed by a simple process and can be used in a number of industrial use. As the denaturants cannot be easily or economically removed, CD is considered to be low risk of diversion or abuse. ST, which is the specifically denatured alcohol, is composed of alcohol and specified denaturants that are more readily removed by simple chemical process, while specifically denatured spirit is not fit for human consumption by virtue of denaturants used to denature the product. It can, through certain recovery process, be made potable. As a result, its use and control through the registration of users, like the paint industry. Otherwise, everybody user is going to go out. Today, there is no mechanism by virtue of which the user industry, what they do with the denatured spirit which they procure. There is no control except the state laws which are controlling, like through licensing, returns filed by them. There is no law which prevails. And just one more page on this, Malas, how the formula of these two are given, and look at the extent by which these two type of categories of product, PDF 139, Malas. A category, the formula for denatured alcohol. A category is completely denatured alcohol, which are safe, are low in risk. Look at B, specifically denatured alcohol. These are the products which are there. And these are regularly being purchased and sold and consumed by the user industry models. And this is under the high risk, as a matter of fact, which has been found to be a problematic area.
Genuinity in making what is non-portable portable.
Yes, but as a straight, I asked this question that why somebody is going to do this. The 350% of the excise duty is saved straight on this one.
Intoxicating.
Even plastic soda.
Medical products like cough syrups.
So you're done now?
That's
Thank you.
Great.
So, Mr. Faraz, we'll take your submissions 15 minutes or so. You can argue to your heart's content, but about 15 minutes. That will then request the other sides.
5 minutes. 5 minutes.
क्या बहस करेंगे?
हाँ सर.
Yeah.
Please, my lords. Because I appear for the state of Punjab, and my lords, I have one submission, and that is that the semantic meaning of intoxicating liquor, which existed at the time of the Constitution coming into force, includes the entire universe of alcoholic fluids. And that is the meaning your lordships to give to the phrase intoxicating liquor. Because I framed the submission in this manner, trying to pivot it at the time of enactment of the Constitution, for the reason that the meaning of the word liquor itself has changed over time. Liquor, what it meant, my lords, 30, 40 years back, certainly at the time of introduction of the Constitution, is not the meaning which is there in common parlance or the predominant meaning today. So, my lords, my respectful submission to the court is...
One thing is very clear, coffee has not still become liquor.
That's true. That is true. Plus,
Again, it depends on who drinks.
There are many liquor substitutes, but it's not liquor under the Constitution.
Otherwise, then we'll have to review what we said about the Attorney General.
I tried to make good my point.
Well, in fact, my submission will be that liquor definitionally includes all fluids. All fluids. That's one of the primary meanings at the relevant time. And I'll take your lordship to the dictionary meaning. So how your lordships interpret intoxicating liquor will first depend on how your lordships interpret liquor itself.
Intoxicating liquor is a species of liquor.
That's right. I'm grateful to the court. So, my lords, intoxicating is a word which qualifies the word liquor. So, and in my respectful submission, a great deal will depend on that. Because if your lordships take the view that liquor is all possible fluids, then it is certainly possible for us to argue that intoxicating liquor includes all liquors which have alcohol in them. That is, which have the capability to intoxicate, whether they are drinkable by humans or not. But if your lordships take the view that liquor itself means only alcoholic fluids, then attachment of intoxicating to it will certainly have a different meaning, which may indicate that it has to be fit for human consumption. In my respectful submission, there are two broad cleavages: pre-synthetics 1990, that is pre-synthetics 2, and post 1990. And what is pre-1990, the meaning of liquor was what I'm suggesting the court to adopt, which is also the meaning in Balsara. That is, it's all fluids, and therefore intoxicating only qualifies it to make all fluids which contain alcohol in any form. And synthetic breaks that meaning and form, and post-synthetic, some judgments have already been placed before the court, the meaning changes. And this, my lords, error begins in para 70, if I may respectfully say, error of synthetics is in para 74 of the judgment, which is at PDF page 55. My lords will just have it. It's been shown.
We just saw it in the morning.
Yes. The bottom part, I'll just read it. Lordships will not go to it. The above entry contains words intoxicating liquor. The meaning of the expression intoxicating liquor has been rightly interpreted by the Bombay High Court in Balsara. So, the Supreme Court here goes with the Bombay High Court view in Balsara, not the Supreme Court view. And what does it say about the Supreme Court view, which is Justice Fazal Ali's view? The decision of the Bombay High Court is repeated in so and so. In that light, perhaps the observation of Fazal Ali J in Balsara case requires consideration. It appears that in light of new experience and development, it is necessary to state that intoxicating liquor must mean liquor which is consumable by human being as it is, and as such, when the word liquor was used by Fazal Ali J, they did not have the awareness of full use of alcohol as industrial alcohol. Well, just if your lordship will just come to that page 47, there's something which turns on that. I want to just
para 74, page 54, right?
Page 55 PDF begins at 54 at 55 PDF.
So Balsara dealt with a case of prohibition.
That's correct. But
prohibition for human consumption.
But
alcohol for human consumption was prohibited. Then it was challenged on the basis of Article 19(1)(g), because if you have a complete prohibition, then such product is not available as a raw material for toilet preparation and for another medicinal. Therefore, they struck it down on that basis.
Plus the words liquor and intoxicating liquor both were interpreted in that.
And for Mr. Balsara to have prohibition would have been blasphemous, absolutely, you see.
That is another main aspect.
Balsara.
The Bombay Act, if I may answer, the Bombay Act contained the entire universe, including spirits of all kinds, was varnish, everything. So the Bombay Act in that sense was the entire scheme of liquor, not just. That's true. It arose in the context of it. That's true. It arose in that context, but the interpretation was of the entire act. Page 55 PDF. Page 55 PDF. It appears that in light of the new experience and development. So
But can you just now, okay, this we have seen.
Yes.
How do you say that, the definition of liquor, pre-synthetics, would include all fluids? Of course, one is, of course, what, common sense. We always say liquor in coffee. Would you like to have just the liquor, or would you like the liquor with some warm water? They ask you all the time when you go down to Bangalore or when you go to Chennai. But they'll ask even the Attorney General whether he'll have some liquor, you see. But is there something more substantial we are missing to show that liquor would mean all fluids?
Well,
I mean, that was the conventional meaning. Forget Balsara.
So your lordships will have volume 1I. I have put all the dictionary meanings of all the dictionaries of the relevant time. The ones I could find. 1I. It's page 1. PDF page 2. The first one is the Law Lexicon of British India 1940. What was prevalent in British India at the time? So I've taken the liberty of putting it all in one place. Liquor, a liquid or fluid substance.
Volume 1.
1I. I for India.
1I.
There are two meanings possible. The
in
second,
a more limited sense.
That's
and
right.
it's more common application.
So there-
Spirituous fluids.
correct. Your lordship is absolutely right. So there were two possible meanings, but this meaning which was there of liquid has always been there at the relevant time. And my submission is that liquor used in entry 8 is in the broader sense, which was prevalent at the time. It was a usage available at the relevant time. Today, if your lordships will go to dictionaries, just even if your lordships Wikipedia, liquor equal to fluid bracket, it will say obsolete. Because nobody today uses. And we should not use our contemporaneous understanding of the word liquor and impose it on 1950s, my respectful submission.
talks about spirituous,
Also,
not virtuous.
Virtuous, I also say exactly what struck me. So spirituous and not virtuous.
let's kindly have Webster's number 2. Liquor, a liquid substance, and then again, the examples are, it's also used in the second context of a alcoholic drinkable fluid, but it's also used as a fluid per se. And if you watch this, we'll go down to the etymology of it. Liquor effectively is from Greek, which means fluid. Sorry, Latin, which is essentially fluid. That's the true pure meaning of liquor. Now, obviously that meaning has evolved, but my respectful submission to the court is at the relevant time, one of the predominant meaning, possibly the predominant meaning was any fluid.
But then do we interpret the constitution in terms of its original understanding, or we understand it?
I'm so grateful. So that's why I began by framing my argument as the semantic meaning. Your lordships will examine the semantic meaning. I'm not proposing an originalist understanding of the constitution. That's never been our jurisprudence anyways. But to begin with, my lords, your lordships will always examine the semantic meaning as it existed. Then your lordships, after having determined what the original semantic meaning was, expand it if necessary, change it if necessary. What synthetics does, it mixes up, it says language has changed, therefore I'll now superimpose that on 1950. For instance, my lords, sex does not include sexual orientation. Your lordships have included it. But your lordships did not say sex originally included sexual orientation through expansionist process. Your lordships did not change the semantic meaning. It remains intact. Your lordship says situation has changed, society has changed, therefore we will now bring this into. What the synthetics code does, it changes the semantic meaning. That's what I was reading at 74. It says experience has changed, liquor today means this, therefore this is what it is. Because that, in my respectful submission, is not permissible. It is nobody's case that something has changed. So the liquor original meaning is any fluid. The constitutional originally envisaged any fluid, and today's situation has changed so that we need to bring in something else. That's not the way. They said the language has changed. And I'll place something on that. Well, there's a very good article by a Yale law professor, because in US, in Article 4 of their constitution, they use the word domestic violence.
Domestic
violence. That's actually internal disturbance. But in 1780s, the word domestic violence was in vogue. What they mean is internal emergency. Today we will associate domestic violence with spousal abuse. So the meaning of the word, your lordships will first determine what liquor meant then, what intoxicating liquor meant then, and then after that semantic meaning is clear, your lordships will interpret it further if necessary. That the synthetics court has not done.
By the way, Mr. Parasat, where did you get all these dictionaries as of 1950 from?
I am grateful to the court. Actually, I use the judges' court library. Nowadays, they permit us. So, yes, last 2 days, my colleagues went to the library and we could access it from there. So, I'm really grateful to the court for that. So, your lordships will see. So, the meanings 3 and 4 are also there. Then what, if your lordships will stay on this, kindly have page 3. PDF page 4. Borrowing from justice.
I passed.
Will have PDF 4 of the same volume. As I've tried to borrow from Justice Hidayatullah's concentric circle in the context of public order, national security, public order, law and order. And in my respectful submission, in our case, liquor is the biggest outside circle, which includes all fluids. Within that, you have intoxicating liquor, which is all fluids which contain alcohol. And within that, the smallest circle is alcoholic liquor or intoxicating liquor fit for human consumption. Now, what, my lords, the synthetics court has done, it has gone from liquor to really intoxicating liquor for human consumption. That middle thing has been missed out. So that's why I'm saying, how do we if your lordships take a meaning of liquor, then your lordships will see what does it really qualify the word intoxicating. And then what is the effect of that? The effect of that is, let's say, denatured spirit. What is troubling the court? It really is one thing which comes out of it. So for everything else, it's covered in entry 8. There is no other substantive entry for denatured spirit or alcohol. So that's the only thing which is plucked out suddenly and hangs in the general entry of industry. Why should that be the case, I ask myself. Especially if at the time when the constitution was enacted, one of the known accepted meanings of liquor was fluid, and intoxicating liquor does mean clearly that anything which contains alcohol.
In fact, the argument of denatured spirit is by the states. Balbir Singh was appearing for Maharashtra, because the argument is because even denatured spirit is capable of being renatured in certain cases. Therefore, give us that power as states to ensure that there is no such abuse.
I'm grateful. So that supports my point, because it's not as if denatured spirit is a category which is independent and not interchangeable. That's all the more reason your lordships will give intoxicating interpretation which will include all alcoholic liquor.
All right, what else?
Just finally on that, the next is this article by your lordship's question, the Chief Justice's question on we are not. Your lordships will just pay.
Suppose for a moment, just to test it, you don't accept this submission of yours. Can we not reach the same conclusion by saying that, look, assuming therefore that denatured spirit goes into IDRA, unless there's a notified order, the state's power under entry 33 is not taken away.
But
it will arrive at the same conclusion. But tomorrow the difference is Government of India can come out with a notified order.
Much inferior.
But they have not done it for the last, they'll not do it because they have not done it.
That's true, they have not done
India
it.
India has also changed. I mean, there's nothing so great about industrial alcohol that the government has to regulate.
It's quite clear. It's possible they may not do it, but the nature of the power itself is different, because this is constitutionally demarcated to me if I have it in entry 8.
That is dependent.
Then I'm dependent on their goodwill. I mean, that's really so. As a state, Malad, I would press your lordships to bring it in that. Although immediately it may not impact me even if it comes there, but then later on they can obviously bring in something, notify something, and I'm ousted.
I know, but also, now you have to also understand, IDRA itself is an anachronism. It's just survived, that's all. IDRA is one of those, it's one of those, License Raj Acts, which has also the scope of the act has been reduced now. There's no expansion of IDRA entries. What remained has remained.
Well, that's quite true, but in the
like the controller of capital issues. It was a time when, when everything was so tightly regulated.
Effectively being monitored.
Yeah, of course.
It's not just an RPF law. There is a separate ministry. Under Ministry of Commerce. Separate.
Well, I will only.
But Mr. Solicitor, what we are saying is IDRA is now not, we are not today in a stage of the economy where IDRA is being progressively expanded. It's now
Broadly, your lordships are on a broad.
on where the economy is going.
Yes.
I'll just say one thing in response to that, that when I was in the post-GST era, for the states, any available spaces
are important.
So that's why we would press in entry, because most of those spaces have been given up.
All right, thanks.
Well, just one on that, just so that to elaborate, your lordships will have the article at page 4. And I'm just going to read one page out of it. This is by a Yale professor, Jack M. Balkin, constitutional law professor. It actually just states what our legal position in India, any event is. I mean, of course, in US, originalism is very expansive. We don't subscribe to it at all in that sense. But we do subscribe to it in the way he frames it, is my respectful submission. And your lordships will kindly have PDF page 8.
Which volume is it?
Well, this is 1I. Same volume. It begins, my lords, PDF page 8 with the first line, but fidelity. My lords have it. Regular page 7, PDF page 8. But fidelity to original meaning does not require fidelity to original expected application. Original expected application is merely evidence of how to apply text and principle. Each generation is charged with the obligation to flesh out and implement text and principle in their own time. They do this through building political institutions, passing legislation, creating precedents, both judicial and non-judicial. Thus, the method of text and principle is a version of framework originalism, and it views living constitutionalism as a process of permissible constitutional construction. The term original meaning can be confusing because we use meaning to refer to at least 5 different things: semantic content, practical applications, purposes of functions, specific intentions, as associations. Thus, when we ask the meaning of equal protection clause, we could be asking what concepts the word in clause 1, clause point 2, how to apply the clause, the purpose or function of the clause, the specific intention behind the clause, or what the clause is associated with in our minds or more generally in our culture. Fidelity to the original meaning in constitutional interpretation refers only to the first of these types of meaning, the semantic content of the words in the clause. We follow the original meaning of words in order to preserve the Constitution's legal meaning over time, as required by the rule of law. Otherwise, if the dictionary definitions of word change over time, their legal effect would also change, not because of any conscious act of lawmaking or even political mobilization, but merely because of changes in language. And this is the example. So, for example, when Article 4 says United States must protect the states from domestic violence, we should employ the original meaning riots or insurrections, not the contemporary meaning of spousal assault. Plus, I will conclude by saying that your lordships will examine first what the original meaning of liquor in 1950 was, and then we'll see what is the qualification which intoxicating offers. In our respectful submission, it contains the entire universe, and not just until 1990, right from 1873, when the first Bombay Act was passed, that's the earliest act, till 1990, even denatured alcohol is clearly included in intoxicating.
Really?
Till 1990, synthetics judgment, plus denatured alcohol is in effect included in intoxicating liquor. It's only synthetics definition which takes it a changed view based on the change in what intoxicating liquor means in society. So it is not as if it's something new to us. That was the meaning which prevailed from 1873. All Mr. Dwivedi showed you lordships from all those acts. The meanings was quite clear. It included everything, including denatured alcohol.
Thank you.
I'm extremely grateful.
Thanks.
Volume 1B. Applying for the intervener in IA number 237338 of 2023. Private
Who's the intervener?
Pardon, sir?
Who's the intervener? Last time you told us you are the intervener.
No, sir. I am not the intervener.
Last time.
His daughter was the intervener. That is the private individual party, citizen of India and the resident of Uttar Pradesh. Miss Sheila.
Miss?
Sheila Sharma.
Sheila? Sharma.
Yeah.
Is she a teetotaler?
Pardon?
Is she a teetotaler? She must have locus standi.
Yeah, sir. Lordship, I have the locus.
Teetotaler means chai hi peete hain.
Pardon?
Teetotaler means chai hi peete hain.
Sir, can I start?
Yes, yes.
How she is affected by the issue involved?
Pardon, sir?
How she is affected by the issue involved?
Yes, sir. We are talking about the industrial alcohol. And this industrial alcohol is many times for the direct human consumption. And I give the example, like in the cosmetic industry, the nail polish.
People drink nail polish.
No, sir. Human consumption, when we using the nail polish, then it comes in the direct contact of the skin, and it is also the human consumption. We are wearing this cloth, it is also the human consumption. How can we say if we eat or drink anything, then it is the human consumption? The constitutional entry mention the word only the human consumption. That is not saying that we should eat, we should drink. So that's why, sir. Can I start?
Thought you were done and you made the point.
No, Learned Council, I thought you have completed.
No, sir.
Okay, so
Only I am explaining my locus.
So human consumption doesn't necessarily mean that you have to eat or drink the product.
Yes, sir,
Then-
absolutely. Sir, can I start?
Yes.
The main issue is the interpretation of the section 18G of the Industry Development and Regulation Act 1951 with regard to state legislative power for the industrial alcohol. This is the main issue in this matter. So on the last page of my written submission, the last paragraph, I will read only four lines, and after that I will say anything. Mere existence of section 18G of 1951 IDR Act in the statute cannot out the competence of the state legislature to enact the legislation in respect of the matters falling under entry 33 of the list 3 of the 7th schedule to the Constitution. States' power to regulate the use of alcohol, which would include the power to make the provision to prevent or check industrial alcohol being used as intoxicant liquor, should be recognized. So, sir, we are talking here, this is the industrial alcohol. This is the non-industrial alcohol. But there is no way the clear-cut division. Denatured alcohol, intoxicating liquor, as I said previously, is also for the human consumption. Like, sir, Lordship, in this courtroom, we use the spit polish. We use the spit polish on the wooden walls. In this spit polish, when we sit on the dais, we direct, you can say, in the skin. So that's why, how can we say many products of the denatured spit directly in the human consumption and some indirectly in the human consumption. That is the way. And also,
What is your
pardon?
What is your name?
Dr. Vivek Sharma, sir.
So Dr. Vivek Sharma, you are saying that ये जो लिकर की बात हो रही है, इसके लिप्स के साथ कोई संबंध नहीं है ना? यही कहना चाहते हैं, कंजम्पशन माने लिप्स के साथ संबंध नहीं है.
Absolutely, sir.
है ना?
Absolutely.
समझ गया हम लोग.
The things are overlapping, not the clear-cut division of the human consumption.
Sharma ji, is the intervener also related to you or no?
No, sir.
Just the name is the same.
Yes, sir. Absolutely.
Achha, idea.
And, sir, with regard to entry 8,
last point.
With regard to entry 8, when we are talking about the intoxicating liquor, many times before 70s and 80s, we can see in the labs the spit lamp in the laboratories are used, and also nowadays also in the schools going children can use that. Many lecturers of that time and the students directly drink that.
Directly drink what?
the intoxicating liquid denatured spirit which are using to light the spirit lamp. So that's why there can be no clear-cut demarcation. All the things are overlapping. Because sir, at that time in the village and the small towns, schools are available, but not the shops of the liquor.
Yes.
May I start, sir?
It's not a hop, skip and start, you know.
You came to the last para of your
Yeah, yeah.
submissions now.
It is over.
Now we have completed. Now, thank you.
I am
Thank you.
concluding.
Thank you. Thank you, Mr. Channa. Mr. Attorney General.
Only one interjection, bro. He took the matter to the level of Mirza Ghalib. Now, Mirza Ghalib, when he was old, and he used to drink a lot, he said, "Go हाथों में जुम्बिश न सही, आंखों में तो दम है, रहने दो अभी सागरो मीना मेरे आगे। मैं उठा नहीं सकता हूँ, लेकिन मैं आंख से भी पी सकता हूँ." He took it to that level.
What a compliment from the solicitor to you, Sharma ji.
Thanks for the compliment.
That brings a lot of lighter,
Yes.
lesser intoxication. Lordship, please. If we place some broad reflections on why the principle of controlled industry may have different implications at different points of time in a nation's history. If you switch over from a completely controlled economy to a relatively free economy, I suppose even in those circumstances, the need for controlling an industry will always be there, depending upon the implications which an industry may have or may not have on the people of the country.
Today, there may be considerations of defense or national security, which will require a controlled industry.
So what I was listening to him is old 1932, the ice company case in New York State Ice Company was a Lehman. So what is charged with the public purpose and public interest? So a process, an industry, a thing, a material, an object, any one of them, if they're charged with a public purpose or a public interest, then state will have an interest in dealing with it in such manner as the state may like to do. For entry 52(1 may have to be seen from that point of view. While we have moved away from a license charge, but I said the importance of control of an industry or a process or a thing or a material would always remain in the contemplation of the state, and particularly because Parliament will decide for the entire nation. Well, we're trying on the lighter side talking about intoxication, the whole historical aspects of intoxication. We are not talking about merely probably in one level, the bacchanalian aspect of it. Old Greek word Bacchus, which is used also in Shakespeare's Midsummer's Night's Dream. We call that the root of the riot of the tipsy revelry. So therefore we are trying to look at meanings from a constitutional point of view, which may make sense for understanding the distribution of powers and authorities. Very often, like for instance, the word telegraph. When the word telegraph was invented, they did not know telephone. But courts interpret telegraph to mean telephone. There you are supplying a meaning to the word by reason of an additional invention which has come into the world of science and technology, and human experience comprehends it, and therefore says, I'll give this meaning to the word telegraph. Like Article 25, I give a meaning to life and liberty. But it comes to terms and expressions which have scientific and technical meaning. The court will not supply a meaning in the abstract. It can learn a meaning or pick up meaning only from the experience of technology and industry. So, regardless of the fact that all liquids containing alcohol may be brought within the broad term of a liquor, the constitution makers would have thought that why don't we use the expression liquor? Why resort to intoxicating liquor? Liquor would have been the most easiest expression because that's how common sense, industry, everybody understood it. But an intoxicating element was brought into it. One must ascribe some relevance to that addition to the word liquor. I'll come to it a little later, trying to break some broad reflection. How do you go about it? Very often we have this problem about definitions. Therefore, we are looking at a thing which is being defined, a liquor, intoxicating, which is the thing. And definition of a process or a matter or an idea or a principle. The definition of a word is different from a definition of a thing. A thing is defined by reason of its characteristics, features. A word is defined by what it is can convey over a period of time. So if you're looking at definition of intoxicant as a thing, I may eventually try to probably expand this, saying that the reliance on gas and gas works picked up from out of industry. Intoxicant as another illustration of picked up from industry. It will be valid up to a point, but not beyond a point. And if you're looking at the entire distribution of powers, we understand that the legislative entries are not exhaustive of what Parliament or the state legislature can do. Whatever came into the imagination of lawmakers at a given point of time were brought into these broad enumerations. So today we don't have a public, for instance, public premises was not an entry under anyone's list. And Parliament had to amend the Parliamentarian Salaries and Allowances Act to bring in pension, because the entry is only about allowances and salaries. So the mere fact that certain entry or a matter is not specifically enumerated in any of the list would not come in the way of the respective legislatures to go about legislating and acting in terms of out of a necessity to deal with the matter. Therefore, we don't say that list 7 schedule is completely exhaustive of everything, and something which is not there will fall here or there. I'll presently take your lordship through my written submission. Before I thought I'll do that. Therefore, this whole way of understanding the 7th schedule will be on the basis of what a state out of a necessity would be persuaded to legislate or embark on a course of action. Therefore, the necessity element will always be built in entry 52 list 1. Entry 33 could not have been brought in list 3. If Parliament thought that by bringing in the concept of industry under union control was sufficient to deal with all matters relating to union control, then it could have ended so. So is there a purpose in saying that both Parliament and the state will have a concurrent competence under entry 33? And if so, what purpose will it serve? Either it must serve a new purpose or serve a purpose already in existence and expand its use or its exercise.
But, entry 33, Mr. Attorney, is a clear example or a clear indicator that even while giving to Parliament the power to declare an industry, the control over which by the union is in public interest, the framers did not want to oust the jurisdiction of the states completely. Because...
I don't propose to say that.
Yeah.
The very
Because
fact
that's
is
why
the concurrence.
they felt that no, notwithstanding the fact that the industry is declared as a controlled industry, production, supply, distribution, trade and commerce will be the subject of a concurrent power. So Parliament may override the state, it may not override the state, but the state was also given a power, even though the industry itself is a controlled industry.
Absolutely. I mean, there's no doubt about that. The very language of entry 33.
The extent of control under entry 52 of list 1 is itself in a restricted area. It at least excludes trade, commerce, production, supply, distribution, which is taken to list 3.
We can probably draw a wall of separation between a product of an industry and trade, commerce, supply, distribution. Or we look at them as one continuum of activity, an economic activity of production, and thereafter supply, distribution, etc. We are looking at an economic activity. So there are many economic activities today which may end with merely production, but I don't think today somebody will make sense to say, I will produce, but I will not supply. So every production implicitly includes within the activity of production the next series of actions: trade, commerce, supply, distribution. They are a continuum of economic activities. So that's why even in entry 33, I'll come a little later about explaining it. In entry 33, clause A, it talks about the products of any industry.
Right.
The products, plural, number 1. Any product of any industry. As many products of any industry. So the products of an industry here means in a very expansive sense. In respect of those products of the industry, what is the scope of entry 33? In respect of those products, that can be a trade, that can be a commerce, that can be supply, that can be distribution. So therefore I find there is a symbiotic relationship between entry 52 list 1 and entry 33 list 3. You cannot see them in isolation. And I don't think Parliament would simply say, I will enact a law under entry 52(1) with a mere declaration that it is in public interest. No law would probably do that. It will go further and say, how will I achieve the declaration? Therefore, entry 33 and entry 52, if they are to be seen as two branches of one family, there's another way of looking at Let's kindly turn to volume 2B
Submissions?
of my written submissions.
Volume 2B. Oh, like this.
Where is this article? I placed another extract from a book, which is volume 4D. I'll come to it a little later. Just Lordships make a note of that. It's one of the interesting treatises on linguistics in volume 4D. That's the title of the book is Meaning of Meanings. Before I go to that, let me come to my written submissions.
Let's see proposition 1.
Yes. So entry 52 list 1 has a special significance. Its scope is not controlled by any other entries. I say including entry 8. Entry 24 list 2 contemplates state control or regulation of industries within the geographical frontiers of a state. And entry 52 provides for control aspects from a national perspective. Such a federal control will be based on principles uniformly applicable to all states as far as control of an industry and to serve a national interest. Several national and public interests are perceived to be served by federal control, namely subserving the common good, equitable distribution, fair prices, utility of products of industry, for serving the interests of all the states, etc. The common control element under entry 52 list 1 is an independent subject and is not a matter carved out of the subset of industries under entry 24 list 2. If, stopping here for a minute, if 24 and 52 dealt with distinct classes of industries, one can understand that. Entry 52 is an entirely different subject. It's about bringing industries under union control. The union control is the subject of entry 51, entry 52. Probably it is too stretching to say that from 24, the roots of entry 52 come. They occupy a different space, they serve different purposes, but even in entry 24, what would a state do in respect of industries? When we talk of a thing, we talk about how do we go about regulating the use of the thing, the consumption of a thing. When we talk about industries here, we talk about regulating the industry. Industries even at a 24 is about regulation. It's not anything other than regulation. So 52 is different. Regulation from national perspective. Entry 24, para 5, on the other hand, stands on a lesser pedestal, namely the geographical area. Regulation of industries that be dealt with under entry 24 is district. Entry 24 contemplates the competence of the states to enact and to provide all matters in respect of industries. Entry 52, on the other hand,
the reason why they argued that entry 52 is a carve out is because the subject of industries is contained in entry 24 of list 2. Because entry 24 of list 2 says industries. Entry 52 says industries, the control of which is declared by law by parliament. Now, which are those industries? Those industries are otherwise comprised in the subset of 24. Everything falls in 24, but once Parliament declares by law, that is abstracted out of 24 and then taken to 20 and taken to 52. That's the way it operates. It's not that industries in 52 is independent of 24.
No, my proposition is the subject of 52 is about union control.
Yes, of course, there's no difficulty about that. That you're right.
The union control is the subject there.
That you're right.
Therefore, Parliament could have, Constitution could have said industries can probably be in list 1, but that would not have made sense. In the sense that states will have to look after processes, manufacturing processes, industries within their respective geographical areas. So it is not probably correct to say something is carved out of 24, but entirely a different subject, namely union control of all that can be conceived as industries. So it's different significance altogether.
52 doesn't say industries which have a trans-state location or a trans-state operation. It says industries, the control of which.
Even industries within any one or two or more states, even they can be brought under control under entry 52(1). It depends on the national interest which industries may serve.
Suppose the IDRA was not enacted. All industries will then fall under which entry? Not under entry 97. They'll all fall under entry 24. Suppose an industry is not declared as a controlled industry, even after the IDRA is enacted. Where will that industry fall? It will fall under entry 24.
Article 248, for that matter, says it gives competence to the Parliament to enact laws which are not found in entry 1, list 1 and list 3. So we refer the competence of Parliament to deal with certain matters. Can you look at Article 248 for a minute?
Article 248 is on the same lines as entry 97. Entry 97 is a residuary entry, including anything which is not found in any of the lists.
Entry 97 only captures that, the element of Article 240, but 248 is the source.
So the ultimate residuary power is with Parliament. It's nobody's case that Parliament is using a residuary power here. It's a specific power in the entry 52.
Not enumerated in the concurrent list or state list.
So that is plenary power.
For this, the source of parliamentary power is wider than, let's say, even 97, something which state list fine, Parliament can still enact that. So concurrently it's a state list, see 248. It is not in the state list. Therefore, the absence of an entry in any of the list would not make a difference. As a corollary, if the lists have a certain meaning and also, let's say, a connotation, Parliament cannot say that, look here, I don't look at the intoxicating part of it, I only look at the liquor part of it. Parliament can still do that. I'm just giving an example. Therefore, the entry 52 competence list 1 is something which is untrammeled or unconditioned by any other entry in the 7th schedule. Why I wanted to say that is this. Whichever way the court may look at entry 8, whichever way one may look at it, will not control entry 52 list 1.
There's no question of control.
Calcutta Gas Company judgment has been relied upon to show that we have 3 entries in list 2. Gas and gas works, intoxicated, and probably what other entry, namely fisheries. I tried to find out what would probably be any other entry which can be taken out of or treated as a subset of industries. We find these 3 entries there. One probably would think that the reason for a gas or gas works or fisheries or intoxicating liquor to be treated as a separate entry, one of the reasons can possibly be that a special and attention will be required to be bestowed on these things and on aspects, which otherwise, under the general entry 24, the state can easily achieve the same object. If industries means regulation, control, supervision of trade, commerce, supply, distribution, you can't probably give a narrow meaning to the word industries in entry 24. So if it has all the plenitude of meaning, a state can even at 24 achieve the same object of controlling, regulating, supply, etc. But if there is special attention to be bestowed on a particular subject, for reasons of the historical significance. So if from 1880 onwards, liquor has had a meaning, particularly with reference to the portability part of it, the human element part of it, the consumption part of it. For gas and gas works, if we did not know prior to 1935 the manner of production of gas and the new industrial use of gas, etc., it was a certain understanding on the historical meaning given to gas and gas at a given point of time. Therefore, there are 3 or 4 entries in list 2 which are specifically taken out, if one may say that, out of industries for certain very special reasons. That by itself does not mean they would not otherwise come within the scope of industries. In Calcutta Gas Works, the analysis by the court that there is a possibility of contributing to entries in the state list. And having in mind the 1951 Act, if there is a control element brought in there, look at what should happen to the state law. I'll come a little later to why Calcutta Gas judgment may probably require the reconsideration.
Submissions were kind.
I just go to my second proposition, number 2. To give a symbolic or metaphoric, these entries in the 3 lists are not like the Berlin Walls. They always have an interplay. And one can jump.
But suppose no declaration is issued by Parliament in a law under entry 52.
Yes.
In relation to an industry. Under what list will that industry fall?
It need not fall under any particular entry anywhere.
No, it has to fall somewhere.
That's what there's an industry. Today there's an industry which is not in any other list or even or not.
There's no declaration issued by Parliament in respect of a particular industry, industry A.
Yeah.
Where will it fall?
No, that inquiry, from my understanding, that inquiry may or may not be relevant wherever it falls.
No,
I'll just come to
relevancy we'll decide later, but suppose a declaration is not issued by Parliament.
If a declaration is not made under entry 52 list 1, then entry 24 will certainly operate.
Right.
That's not the problem. But the question is, entry 24 operating ex proprio vigor, right? In the absence of a law under entry 52 list 1, that may have no relevance to what Parliament can do in entry 52 list 1. It may be an industry under 24, whatever be the industry. 52 occupies an entirely different, issue altogether, subject altogether. So whatever be the industry, can Parliament not control it? It is not it is the nature of the industry, as I said, the various purposes that will be served by controlling the industry. The moment you enter into discussions on what are the other entries in state list, which may have a bearing, a relationship or otherwise with entry 24, and therefore will it control entry 52 list 1? I think that's a long line of inquiry. Begin from a wrong side. This is untrampled, as I said. If tomorrow Parliament says, I don't need an Industrial Development Regulation Act, and so be it. But as long as the law occupies the field, and Parliament has continued to say, well, I will insert various industries in the schedule, it evinces an intention to have a union control principle in position and to bring in from time to time industries within the schedule. Please come to page 3 then. Proposition number 2. Certain entries in Schedule 7 constitute a family of entries in as much as an element of interconnectedness between them exists. Entries falling within such a family cannot be seen in isolation, and in a sense they are complementary. Entry 52 list 1 and entry 33 list 2, 3 should be, is such a family of special class. The principle of control enunciated in entry 52 of list 1 can also include and touch upon all matters relating to an industry that is brought under union's control. These matters can be production, trade, commerce, supply, distribution, etc. Depending upon the nature of the industry to be controlled and the public purpose such control of the industry will serve, Parliament can deal with any one or more or all of the above mentioned aspects of the industry. To the extent that the Parliament may deal with these matters, the competence of state to legislate under entries 26 and 27 of list 2 will be excluded or deluded. Entry 33 of list 3, however, is a coordinating branch of the principle of control. Trade, commerce, production, supply, and distribution of commodities or products are interconnected aspects of an industry. Entry 33 contemplates that Parliament will have the primary competence of legislating in relation to any one or more or all of the above matters as may be deemed necessary towards the control of an industry. The primary competence dimension flows from the control aspect, the foundation for any further legislative exercise. Depending on the scope and extent of parliamentary legislation providing for control, the subjects which are not occupied by parliamentary law will be available to be dealt with by the states. When I say the primary competence of legislating, therefore entry 52 flows into entry 33. Para 5, the view taken in paragraphs 14 and 15 of CLS Union of India, suggesting that a division between entry 52 list 1 and entry 33 list 3 does not offer a correct view on the reading of the above said entries. The aforesaid paragraphs are extracted hereunder. If you apply the same principle of harmonious construction to entries 24, 26, and 27 of list 2, the term industry in entry 24 would not take within its ambit trade and commerce or production, supply, and distribution of goods, which are the express province of entries 26 and 27 of list 2. Stopping here for a minute, I suppose 24, 26, and 27 are a family of entries. 24 talks about industries. Once an industry, an industrial process, a production happens, everything thereafter is the continuum of an economic activity. For the purpose of felicitation and easy dealing with those matters, 26 and 27 are subdivided. Even if 26 and 27 are not there, 24 can still take care of all that under 26 and 27. If we read paragraph 14 again. If you apply the same principle of harmonious construction to entries 24, 26, and 27 of list 2, the term industry in 24 would not take within its ambit trade and commerce or production, supply and distribution of goods, which are the express province of entries 26 and 27 of list 2. Similarly, entry 52 in list 1, which deals with industry, also would not cover trade and commerce in our production, supply, and distribution of the products of those industries, which fall under entry 52 of list 1. For the industries falling in entry 52 list 1, these subjects are carved out and expressly put in entry 33 of list 3. So what I find there is what I call the Berlin Wall. No. So 52 and 33 are so interconnected. They're carved out, I say, for the facility of a state dealing with the subject. Let me read paragraph 15. In Calcutta Gus, the judicial of this court in Tikaramji was relied upon. Tikaramji is the case the court inter alia considered the interrelationship between entry 52 list 1, entry 24 list 2, and entry 27 list 2, and entry 37 list 3 as it stood prior to the amendment and is amended. This court examined the contention. The term industry should be widely construed to include all activities, including activities preceding production, such as acquisition of raw material, and activities subsequent to production, such as disposal of the finished products of that industry. Negativing this content in the light of the legislative entries, this court held that what would fall under entry 24 of list 2 would be the process of manufacture or production, except where the industry was a controlled industry, when it would fall within entry 52 of list 1. The products of industry would be comprised in entry 27 list 2, except where there are products of a controlled industry, and they would fall within entry 33 of list 3. Therefore, the subject matter falling within entry 26 and entry 20 of list 2 would not be covered by entry 24 of list 2. And similarly, the subject matter falling under entry 33 would not fall under entry 52 of list 1. At one level, it is correct, but at a different level, it is not. Because the entry 33 is not about union control of industries. But what happens along with union control is what is stated in entry 33. So union control must mean something beyond mere union control. It must mean the aspects and dimensions of union control. Therefore, I find in this reasoning in CL some kind of a wall of separation, which probably is not the adequate way of reading entries within the same list. Since I would like to make some submissions with regards what happened in Calcutta Gas. So if entry 24, 26 and 27, they all fall in list 2. So there is no need or a necessity for suggesting a conflict between these entries. They may overlap or there may be some distinction between these entries. In Calcutta Gas, what the court came close suggesting there's some kind of a conflict between antithesis between entries 24, 26 and 27. Or gas works and entry 24.
27, they have to yield to entry 52 list 1 or entry 33 list 3 as the case may be.
That's true.
So they have to yield.
That's true. I come to it immediately. But what I'm trying to find out is entries 24, 26 and 27 in the state list. If I call them a family of entries, it's only a distribution of a certain dimensions or facets of economic activity amongst them. Industry, trade and commerce, supply distribution, as I said, to repeat, a part of an economic activity and interconnected. Therefore, as I said, for facility, suppose you only want to do a deal with trade and commerce in an industry, you may do it under entry 26. You want to deal with supply and distribution, you may deal with it under entry 27.
Should be declared first. The entry 52.
That's right. As far as they are being subject to entry 33 is a different issue altogether. Because I had some difficulty in going ahead with the reasoning in CL. Therefore, I'll come back to it a little later.
33 list 3 is also with regard to a declared industry. That is the common thread.
That's right. That's right. Let me now continue to read at page 5, PDF page 5, paragraph 6. The reliance in the above judgment on Tikaramji for his conclusion does not seem to be correct. As stated above, entry 52 list 1 and entry 33 list 3 are two branches of one tree and they reinforce each other. On this understanding, the further conclusion that can be drawn is that it is open to the Parliament to enact in respect of matters relating to trade and commerce, production, supply and distribution, and also deal with the necessary elements of control and regulation touching upon the above subjects. The Industry Development and Regulation Act 1951 has enacted in respect of and provided for aspects of control and regulation touching upon trade, commerce, production, supply and distribution. The purposes of exclusion of competence of states from entering into any one of the above matters, namely production, etc., it is sufficient that the 1951 Act has touched upon the area and the nature of control and regulation vis-a-vis the scheduled industry. Then a law is said to be complete and made insofar as it contains all the essential features of a legislation, including provisions in relation to delegated legislation. The mere fact that the details of the working of the legislation will be dealt with by way of rules, regulations, notifications, I was reading in paragraph 8.
Yes.
The mere fact the details of the working of the legislation may be dealt with by way of rules, regulations, notifications, and orders cannot be the reason for the assertion that the law is incomplete or that the field is unoccupied. The enforceability or otherwise of a law by reason of non-emanation of the subordinate legislation can have no relevance to the actual occupation of the field in question. It is the occupation and not its enforceability that matters. Not speaking at all or silence on a subject is different from the absence of measures towards enforceability of the statute. And Tikaramji was a case dealing with raw materials not falling within the scope of the scheduled industry. It was in that context that the court noticed that no order was issued by the central government in exercise of the powers vested under Section 18G. Because sugarcane as a raw material did not fall under the scheduled industry, the court felt that possibility of an order under Section 18G being issued by the central government would not be enough. The case on hand is no parallel to Tikaramji. The entire fermentation industry has become a scheduled industry. After the amendment in 2016, one part of the fermentation industry, namely so-and-so, continues to be a scheduled industry. As a result, the subject matter of the fermentation industry as a whole or otherwise stands within the scope of the 1951 Act and within the details of Section 18G. It submitted Tikaramji principle cannot be said to be a principle of universal application. That is, in the absence of an order under Section 18G of the IDR Act 1951, it will be a dormant law and the states will derive their competence to deal with any matters, all or any matters otherwise exhaustively dealt with by Section 18G. In other words, since the 1951 Act has enacted in respect to the entire spectrum of control and regulation, and also the details of their working. For instance, as spelled out in Section 18G, the said Act, there is no unoccupied field at all available to states. Then proposition number 3. Why entry 8 of list 2 cannot be of any avail to the states? The litmus test of entry 8 is from the point of human factors, namely human consumption. The word intoxicating must be seen only with reference to the impact owing to human consumption. That which is not consumable by humans will not fall within the meaning of intoxicating. Entry 51 talks about human consumption, but in a different context. I'll come to entry 51 in a short while. So notwithstanding the long history of definitions of liquor to include liquids with alcohol content, it cannot be canvassed that a human consumption part can be kept aside. All uses of liquids containing alcohol, other than meant for human consumption, would all fall under one heading of non-potable alcohol. Even entry 51 of list 2 talks about alcoholic liquors for human consumption. It's immaterial that there is no entry in the 7th schedule specifically designed as industrial alcohol. The 2016 amendment by way of substitution of entry 26 of the first schedule to IDR Act 1951 must be taken to clarify this position. The reason for focus on intoxication and human consumption is not far to seek. The manifold increase in the uses of alcohol-based products was neither known nor contemplated while legislating with reference to liquor, save prior to and at the time of enactment of the Constitution. The focus was on temperance, regulation of trade and commerce in humanly consumable alcoholic preparations.
Like an intoxicated bee.
What are some fireworks in the meanwhile?
Think of the bee and nothing else.
No, they deleted it.
These are like some footnotes.
It just fell off, on the table itself, it just fell off.
Yes.
So I thought that it was being a little heady with all those words. And today, when I made that comment of intoxicated bee,
Yes.
they thought that now the man has also become. By your arguments.
I think that is the intellectual stimulus rather than intoxication. So you go heady sometimes by reason of the home state, the fire in the theatre. You get intoxicated by some thought or an idea. So paragraph 4, the last line. The focus was on temperance, regulation of trade and commerce, and humanly consumable alcohol preparations. If I'm not wrong, therefore, I think when it is open to the legislature to pick up any of the definitions in various statutes, British and pre-independent, they could have fixed up liquor. If liquor conveyed the same meaning on various classes of liquids with alcohol, with different impacts, with different consumption processes. I suppose in 1888, when the Spirits Act was there, nobody thought of using it for a toilet or a medicinal preparation the way we are doing it today. So the manifold uses which liquids of alcohol in different combination, strength, etc. can be made or put to use is something which emerging science and technology invents and discovers from time to time. Therefore, the Constitution could have said liquor, and it had the same meaning. But at some point of time, I suppose, when more and more understanding about the use of liquids containing alcohol come within the fold of experience, then it's open to Parliament or the statute authority to amend it, modify it, or in a given case where it's possible to give a meaning, as I said, telegraph includes telephone, the court may give a meaning. But where it is not possible, the court will not supply that meaning by itself. So it has to be based on the experience and knowledge which flows into technology and engineering and science. That's why I thought this argument on reading entry 8 narrowly or expansively may or may not have any relevance on entry 52 list 1 and entry 33 list 3.
So we have to give a constitutional meaning.
Yes.
A meaning within the Constitution means a constitutional meaning, not a meaning in the business sense or anything as such.
Right, correct. Let's try to take it a little further. So if I given a very narrow meaning to entry 8, to mean only that which is orally consumable. That which is orally consumable can be an intoxicant. If you go back to the word toxic, even in Latin, toxicum, poisonous. But we can't go to that stage. So therefore, when all these legislation, the pre-British and the pre-constitutional legislation, they probably talked about what is the impact on temperance, oral consumption, what deleterious impact it may have on human consumption. Therefore, it's in that context, regulation of trade, supply, distribution, etc. But even if we read it very widely, now because we are talking about manifold increase in the in liquids containing alcohol, even if you give that manifold, taking into account, give that very expansive reading, I say whichever way one reads that, it's immaterial for the purpose of entry 52 list 1 and entry 33 list 3. They cannot control what Parliament would say and how do I bring it within union control for what purposes. The entire argument is look at Calcutta Gas Works. What did it do? It kept gas and gas works out of entry 24. The same thing you should do as far as entry 8 is concerned. Entry 8 will have a very expansive meaning. Such a parallel, I think, is probably looking at the wrong side of entry 52 list 1. And therefore, I was trying to find out whether whatever be the concept of industries under entry 24, 52.1 is in a different footing altogether. But at the same time, there is some kind of a connectedness between 24 and 52 because they are talking about industries, the industrial processes. So industry ultimately, whichever way one decides for the purpose of Industrial Disputes Act, or even otherwise, an organized activity by reason of which a product emerges. Something emerges out of an organized activity. That's why labor, capital, plus whatever one may call. We have the theory of surplus value flowing from that only. So organized activity leading to emergence of a product or a thing or a matter. That's an industry. So when you want to deal with that as an economic activity, then I will look at various facets of that economic activity. So essentially, industry, in my understanding, is an organized economic activity, which is susceptible of being controlled under entry 24 and to a different level under entry 52, this one, because of a national considerations. May I just quickly, in the same volume,
Syrup which has
even yesterday, sorry, Mr. Attar referred to a judgment to the US Supreme Court on intoxicating liquor. Earlier there was a Master, kindly, you can have a copy. The 18th Amendment was enforced between 1919 to 1933. You were copying that. Amendment, Lord have it. Let me just quickly read that. Section 1. After 1 year from the ratification of this article, the manufacture, sale, or transportation of intoxicating liquor. This here.
Oh, yes.
Manufacture, sale, or transportation of intoxicating liquors within the importation thereof into or the exportation thereof from the United States and all territory subject to the jurisdiction thereof for beverage purposes, is hereby prohibited. The Congress and several states shall have concurrent power to enforce the article by appropriate legislation. That is what entry 8 is about. And on the right hand side, now we have the 21st Amendment. Some slight changes here. The 21st Amendment reads like this. The 18th article of amendment to the Constitution of the United States hereby repealed. Section 2. The transportation or importation into any state, territory, or possession of the United States for delivery or use therein of intoxicating liquor in violation of the laws thereof is hereby prohibited. So what the 21st Amendment thought was the relevance to beverages may or may not be relevant because it's talking about intoxicating liquor as the one common element both in the 18th Amendment and the 21st Amendment. I've looked into all those case law under the 21st Amendment. They all talked about various interstate movement of intoxicating liquor as beverages from one state to state. So the beverage idea is oral consumption of a liquor. Wherever that oral consumption by an industrial process or by any human process makes it possible. At that stage, It is humanly possible to consume a liquor. At this stage, the intoxication dimension of oral consumption comes into play. Otherwise, why would you talk about intoxication at all?
So something which is used for industrial use cannot be a beverage, though it may be consumed otherwise.
There are non-intoxicating
It's
beverages.
not a beverage in the normal sense.
So we are not talking about non-intoxicating beverage, but in beverage, the moment it has an impact on human frame, mind, body, whatever you may call that. Therefore, the intoxication element is the only necessary and essential element of looking at entry 8. But as I said,
Beverage.
even if we give a very broad and expansive meaning to intoxicating liquor, taking into account the various classes of liquids containing alcohol, denatured, whatever one may call them, industrial alcohol, if we give a very broad meaning, even thereafter, entry 8 will not be a springboard for the state to argue entry 52(1) cannot indirectly come and enter into a field in state list. Then we will employ pick and substance, entrenchment, etc., etc. I don't think that's the way of looking at entry 52, list 1 at all. We just quickly take your lordships to, I have set out in the next few pages, 8, 9, 10 onwards. Pick up those paragraphs in various judgments from Balsara onwards to give how the thought process in comprehending liquor, intoxicating liquor, has received a broad understanding in notwithstanding certain shades of difference in different judgments. Let me quickly take your lordship through that. We have Balsara, lordship have page 8, the PDF page 8.
Yes, we are with you.
Then we have Balsara on the right hand side. I have this. After examining various definitions in various provincial acts, concluded the framers of the Government of India Act 1935 could not have been entirely ignorant of the accepted sense in which the word liquor has been used in various excise acts of the country, and accordingly it was concluded the word liquor covered not only those alcoholic drinks which are generally used for beverage purposes and produce intoxication, but also all liquids containing alcohol. That's the broadest meaning possible. I mean, I'll skip synthetic and chemicals now. I'll come back to it later. Then, if you come to serial number 3, which is subsequent to synthetics, State of EP versus Modi Distillery. Look at what this judgment says. So it says, in the light of experience and development, it was necessary to state that intoxicating liquor meant only that liquor which was consumable by human beings as it was. I don't think it will be necessary for our understanding of entry 52 or 33 to get into this very detailed discussion on what classes of liquids containing alcohol exist and which one of them are consumable or not consumable. But if the court were to give that meaning which entry 8 would necessarily carry, having regard to the use of the word intoxicating, probably the court would be asked to stretching entry 8 to such an extent that the court would like to efface out the word intoxicating altogether. You can't by any reading of intoxicating say, I will efface it out. If there is only 1 or 2 or 3 meanings of intoxication, then that meaning which I'll have the more core element for entry 8. But that meaning will be probably the meaning which the court will take into account. We now come to page 14. Entry 8 of list 2 cannot be taken to be the point of anchor for determining the scope of entry 52 list 1 or entry 33 list 3. Entry 8 does not cast any shadow on the above said entries. The ITC ruling was in the context of overlapping entries or in the context of the doctrine of pith and substance for the purpose of comparison of two legislation and locating the dominant purpose, etc. In the instant case, there is no room for suggesting that the state legislation or the rules made by it or within their competence and that the field in relation to fermenting industries was unoccupied. As stated above, the 1951 Act is a complete code by itself and has dealt with all matters referred to in entry 33 of list 3 and relating to the fermenting industry. It is submitted the ITC judgment cannot be any parallel or of any assistance to the instant case. Having said that, may I invite your Lordship's attention to the judgment in Fateh Singh, which is
Volume 5B.
Volume 5B, 5B, yeah.
PDF 554.
PDF 554. Paragraphs you want me to read?
Then, Article 10 is also an indication how intoxicating drinks which are injurious to health. Naturally, it means something which is natural drink. Intoxic. It can't be an alcohol.
The possibility of an intoxicating liquor
Not an industrial
having injurious elements.
Yes. But it should be a beverage
So that mischief is based
for
on maybe.
human consumption.
That's it. That mischief will be the subject of the law. So if it is a non-intoxication element of a liquor, it can be controlled under industries. So therefore, the connection between 8 and 24. 8 is not simply something which is taken out of 24 as an industrial process, but as a subject by itself, as a thing. Liquor is a thing to be dealt with. Yeah. This is the PDF
544.
554,
5B.
volume 5B. 5B. Discussion was about Gold Control Act, versus the Maharashtra Debt Relief Act.
This is Krishna.
Paragraph 2 sets out the factual context.
Money lending is not trade.
That's right. Against the virus of the Maharashtra Debt Relief Act. Then focused on Article 301, etc. Then at paragraph 5, and thereafter at page 558, discussion, another short lethal objection to a part of the law. There was legislative incompetency for the state legislature because it had forfeited the power to legislate on money lending where gold loans were involved, since the parliament had occupied the field under entry 52 list 1 by enacting the Gold Control Act 1965 and thereby elbowed out the state legislature from that field. We'll talk more about that elbowing out as we look into 33 and 52. Now, next.
77.
Page 577. Sorry. Kindly turn to paragraph 54. I'm sorry, sir.
You'll be wrapping up today? So then on Tuesday we can hear the...
I don't think I may have a little more time.
Let's see if we can wrap up, because we've now got the drift, because your submissions are very precise.
Yes.
So we've got the judgments we can make a note of, and we'll look at them over we have this long weekend coming up.
Very well. I may take maybe some judgments where I need to give some explanations and commentaries, because I find this Calcutta Gas and Valsara present some possible way of looking at it, which is being repeatedly invoked to say that this perspective is the correct perspective. So, otherwise, my propositions, in fact, come up the whole.
Clearly covered. Your perspectives have been covered fully.
Yeah. We'll also kindly turn to paragraph 54 at page 577. What then is the incompetence of the state legislature? So-and-so urged that the wiping out of private debts which form the capital assets of moneylenders, when the main thing done by the Debt Act was not in any of the legislative lists, and even if Parliament had residuary power under 97, the state had none. Entry 30 in list 2 is money lending and money lenders, relief of agricultural indebtedness. If common sense and common English are components of constitutional construction, relief against loans by scaling down, discharging, reducing, so and so, will among other things fall squarely within the topic. And that in a country of hereditary indebtedness on a colossal scale, is a commonplace the state legislative heads must receive large and liberal meanings, and the sweep of the sense of the rubrics of must embrace the widest range. Even incidental cognate matters come within their purview. That's what we normally say. Now turn to para 55. The next ground of attack in his multiform presentation is that the gold loan part of Debt Act is void because Parliament has occupied the field. It's also been urged that there is inconsistency between the Debt Act and the Gold Control Act, and pro tanto, the former fails to have effect. Let us look at the basics of the legal situation before us, before examining the wealth of learning counsel has accumulated. Article 246 vests exclusive power for matters enumerated in list 1. State legislatures enjoy power topics list 2 so and so and so. Plainly, therefore, The state can legislate upon any entry in the state list. We may visualize situations where parliamentary occupation may exclude state legislature where, for instance, parliament while enacting on a matter in the union list, states makes as it is entitled to make necessary incidental provision to effectuate the principal legislation. Such ancillary extensions may trench upon state field in list 2. In such a case, if the state makes a law on an entry in its exclusive list, and such law covers and runs counter to what's already been occupied by Parliament through incidental provisions, we argue that the state law stands pushed out on account of the superior potency of parliamentary's power in our constitutional scheme. Again, there are certain telltale heads of legislation in the list where one may possibly invoke the doctrine of occupied field. All that is stated here. Now, skipping entry 52 list 1, Parliament in the Industry Development and Regulation Act has made the necessary declaration contemplated in entry 52 and has occupied the field of gold industry, as is evident from reading section 2 of the first schedule therein. This expression of parliamentary intent to legislate upon the gold industry is enough to expel from the field the state legislature. This is Nariman's contention. But what's the sequitur? Assuming the appropriation by Parliament the power to legislate gold, what follows? It can make laws directly on the industry and ancillary and every allied area, but effective exercise of the parliamentary power necessitates. So much so, business in gold, licensing of gold merchants, regulation of making of pledging gold ornaments, keeping of jewelry, disclosure of gold possession, and the like are incidental to the parliamentary power and purpose of the Gold Control Act and the rules made thereunder. Several sections of the Act, some rules and a few rulings, were read before us to drive home the point that gold loans are already within the ken of the law made under entry 52 list 1 if so what. That is spelled death sentence on the debt act or maintain it or leave it intact. Here we turn to entry 24, the list 2 which runs. Industry subject to so and so. This means that the state legislature loses its power to make laws regarding gold industry. Since entry 24 list 2 is expressly subject to the provision of entry 52 list 1. This does not mean that other entries in the state list become impotent even regarding gold. The state legislature can make laws regarding money lending, even gold is involved in entry 30, entry 34, gambling in gold, impose sales tax on gold, entry 54, regulate with municipal laws under entry 5, trade restrictions entry 26, type of buildings for gold shops, etc. To multiply instances is easy.
This part goes against you, actually. This part goes against you, Mr. Attorney General.
I'll just.
That once there's a declaration under entry 52, it is abstracted from entry 24. But the state can still legislate under other entries which are not subject to.
It may also depend on whether the law controlling it is fully occupied a space or not. That's a different exercise altogether. In paragraph 59, they refer to Kanan Devan Hills. Paragraph 58, this court put the point tersely while dealing with entry 52 of union list. How possibly the federal structure is balanced. This judgment is an authority. So if you look at how the court looked at any other aspect which may have a relation to gold, but not gold as an industry, that is in paragraph 59. Is authority for the proposition that while entry 23 of list 2, in the light of the fact that entry 52 of list 1, Parliament has made a Gold Control Act, has become inoperative to legislate on industry. There is no inhibition whatever in state legislation on subjects other than that particular industry. Money lending is one such subject, and the power to legislate thereon remains intact. So the attempt made here to say that entry 8 is other than industry relating to liquor or a fermenting industry would fall under this test.
Also 60.
Paragraph
60, the next one.
60.
That's it.
We are free to agree that the word industry as a legislative topic has to be interpreted in the widest amplitude. We also find that the fact that dealings in gold, including pledging, have been covered in part with the Gold Control Act. Even so, nothing prevents the state from making the impugned act. That's because about money lending.
Correct.
In Paresh Chandra Chatterjee, so-and-so dealt with an apparent continuity in the Central Act, the Tea Act and the state legislation, the Assam Land Acquisition and Acquisition Act 1948. After examining the scheme of the two laws, the learned judge concluded, a comparative study of both the acts makes it clear. Two acts deal with different matters and were passed for different purposes. So, what is the purpose that we served by the state acting under Entry 8?